Доброго ранку, шановні учасники. Раді всіх вітати.
Good morning, dear participants. We are glad to welcome you all on the second day of our forum.
Спільно з нашими
Jointly with our partner organizations, our esteemed colleagues, we welcome you warm-heartedly on the second day of our event. We are glad to welcome you on behalf of OSCE project, Safeguarding Human Rights Through Courts Phase 2. To start discussion, I give the floor to Alexander Budyanenko. Thank you. Can you hear me? Good morning. Looks like yes. Good morning, dear colleagues. Please put on the screen our presentation. I'm glad to welcome you at this panel. I'm very pleased having with us our esteemed speakers, President of Supreme Court Stanislav Kravchenko, Judge of the European Court of Human Rights Mykola Natovsky, and Judge of the Constitutional Court of Ukraine Viktor Gorodovenko. Topic of discussion is quite difficult. These are quite difficult but practical things connected not only with commitment of Ukraine obligation within OSCE, but we also a candidate for a European Union accession. It's a huge prospect, but big challenges. So we shall discuss these challenges more today. The topic of discussion is on the slide. Interaction between three centers, three pillars of European human rights protection system, in particular, European Court on Human Rights, Court of Justice of European Union, and national courts. That are pillars of responsibility for safeguarding human rights. Within this triangle, where European human rights protection system is, please show next slide. Within this triangle, we can see these three centers of force that are guided by different documents: European Convention of Human Rights, Charter of Fundamental Rights Luxembourg, and Constitution, national system. These are legal documents that are different, but at the same time, national courts find themselves in situation when they must abide both by the case law of conventional law and the case law of EU court and by national constitutions. At the current stage, we have Strasbourg and Convention. We have certain problems with implementation. We are resolving them. With accession to EU, another center arises. First question that I want to ask Stanislav Kravchenko. You being the president of the highest judicial body, yesterday you said the judicial system is preparing to accession to European Union. That's very good. We are learning acquis communautaire materials. It's an important aspect of accession. But my question is, I will speak figuratively and provocatively. Besides one boss, which is Strasbourg, you get other boss, Luxembourg. From your point of view, how to resolve the issue if positions of the two courts do not coincide and the court in Ukraine appears between the two fires. It is an interesting question, but before I provide the answers and start deliberations, I want to welcome you all. Good morning, dear colleagues, dear friends. It's very pleasant to start this morning. What other pleasant thing? First, in my life, I see such a serious presentation considering other things than law. But probably this is the beginning of my answer. In the times when democracy was developing, or just starting, and mankind was choosing the model between totalitarian regimes, formation of this or that, totalitarian model. So we chose our model, which is prescribed in our constitution. Not only prescribed, it could be prescribed but not fulfilled. Totalitarian regime also did have good constitutions, but we may hope that we live in a different way. Coming to the answers to your questions, I want to mention other things. At the beginning, you mentioned that situation is very difficult. It's complicated to implement this thing. For sure, I do not agree with you. Why? Starting from our constitution, it defines that the rule of law, human rights are the highest values. They should be implemented through domestic legislation. But not only that, yesterday we mentioned 27 years we are working with European Convention of Human Rights. I know several years ago, academic institutions were calculating how many references to constitution and court are in domestic courts judgments, more than thousands. Unification of the system. We are functioning jointly for many years. That is true. But it is developing not only by aspiration to build it together. We have some restraint, limitation managed. European Court of Human Rights in Ukraine is often called the fourth instant court. We must say, surely not. We have national constitutional mechanism on the basis that it is our duty of the Grand Chamber of Supreme Court, where this decision could be reviewed and cancelled in criminal cases, life imprisonment and other very important things. We see what is happening. Such is the mechanism of development of the case law. Answering your question, I must say, it's not a boss, but rather partner. We have joint activity. You mentioned three pillars: national legislation, national constitution. I approach it with this point of view. When talking about European Court of Human Rights, we have made a decision long ago and do apply it. The question with Luxembourg Court, it's relatively new, and I will not hide it, it's quite new for me. We knew this court, we knew what it is doing, but in practice we were not using it. And with rapprochement of our integration, we started doing it much more. There are two decisions with reference to their case law. Some people say, oh, it's too early, but we don't think it's too early. We can develop our case law using their criteria. In case there are disputes between the two courts, being a lawyer, being a judge, well, judge means rules and law. Yesterday I mentioned Article 9 of Constitution. This is a part of our legislation. European Convention of Human Rights, I mean. and through a special law, judgment of European Courts of Human Rights that we see as part of Convention, it's a requirement. Answering your question directly, first of all, we must use the case law of European Court of Human Rights. But the discussion can arise, and it does happen quite often, extensively, especially in grand chamber, and there are many judges present. We always try to look at the situation not directly. What I mean, if the question is so interesting, so debatable that we see in practice of Luxembourg Court, the approaches are more interesting, more creative, and the most important thing, the question of protection of human rights is better regulated in that judgment. We shall try to use it. And I hope very much that we shall get a proper assessment from European Court of Human Rights if it reaches that. That is my answer. Thank you. Stanislav Ivanovich, you have emphasized a very important and very powerful issue, role of national courts. European Court, Court EU, has not immediately become the court that is reviewing cases of human rights. We can recollect a first decision of 1917, that other decisions followed, but a very important moving engine was national court, constitutional courts in particular. To some extent, I may say that creation of the charter was a product that became a result of a dialogue between constitutional courts and Luxembourg. As far as I understand, Viktor Horodovenko wants to comment this issue of triangle.
Я також перед тим, як вступити безпосередньо до дискусії, хотів би від імені суддів Конституційного суду, секретаріату Конституційного суду,
on behalf of the justices of the Constitutional Court and the Secretariat of our institution and Oksana Zhitnik, who would also participate in the discussion a bit later, to thank the organizers, the Chief Justice, Mykola Gnatovsky, all of the organizing institutions for the invitation to participate in this event. I would like to speak on behalf of the EU Court of Justice, and in this capacity, I would agree with Stanislav here that the very beginning of the discussion, dear colleagues, dear judges, other legal professionals, and students, should note that Alexander Vodyannikev put into one boat, so to say, all Ukrainians, together with the Chief Justice of the Supreme Court and Ukrainian judge in the European Court of Human Rights. And in this boat, we are supposed to navigate between the rock and the hot place, that is between the Scylla and Charybdis. And it is not an easy thing to do. Our Ukrainian boat should navigate in those uncharted waters of the various legal systems, and we have to know what our goal, what our destination is, with the understanding of how the legal system in this country should evolve with due respect to the human rights within the triad that is promoted by any true democracy. Since Alexander Vodyannikev has asked me a very specific question as to the role of the constitutional courts in this entire system. I would refer you again to the history, because from the very moment of the establishment of the Luxembourg Court, that's back in 1984, sorry, some researchers say it was mid-70s, but as far as I know, the Luxembourg Court did not consider that issues related to the fundamental human rights would be part of their jurisdiction. They recognized the jurisdiction of the Strasbourg Court, and they were focused on the issues related to the foundations of the European community. The constitutional courts, national constitutional courts of Europe, that is the German Federal Constitutional Court in 1971, in the case Zolanda, no, a different one, Internationalis. It's difficult for me to pronounce the name of the company. And when the Federative Constitutional Court of Germany stated the most understandable thing, if the statutory documents of a company or an international organization do not refer to the fact that this international organization or company guarantees and safeguards the fundamental human rights, then according to the fundamental law of Germany, no part of the sovereign powers can be delegated to that international organization. And this court assessed in this context some of the acts of the European community. And the Constitutional Court of Italy, in addition to that, stated that if the fundamental human rights enshrined in the Italian Constitution and in the European Convention would not be adhered to and promoted by the European Economic Community, then Italy reserves its right to exit that community. So we've got with us Professor Tatiana Komarova, and she is a specialist in this area. So I would like to also thank Tatiana and Professor Tsuvina, since all of the negotiators present here and our esteemed agent for Ukraine to the European Court for Human Rights. It's thanks to them that we appreciate the importance of preparation, very thorough preparation for the screening process. And it was thanks to these people that we presented Ukrainian position with dignity. That was our first step, but you know that the entire path would not be a path of roses. And quite recently at the third Mariupol Forum, I read the press release of the ECHR regarding the case Electromash, as far as I can remember, versus Romania, which read that the European Court of Human Rights would recommend that the national courts should not be using the interpretation provided by the Constitutional Court of Romania, and that this interpretation would not be the ground for their disciplinary liability. It wasn't the first press release to this effect, but it was the most recent. So that's how we should consider all of these issues. And I would like to start this discussion from defining the notion of, and I hope that Alexander will help me in this, the notion of the constitutional national identity. Why is it so important?
В присутності Миколи Миколаївича розповідати про погляд Європейського суду з прав людини буде
Now,
некоректно
I
і
would
неправильно.
not be commenting on the position of the ECHR because we've got Mr. Gnatovsky by, and I think that he would be in a better position to do so.
Я пройду по суду справедливості, поки їх тут немає.
So I would be commenting on the position of the Luxembourg court.
Використав поняття конституційної ідентичності, потім злякався.
Actually, Strasbourg court did use this notion of national constitutional identity, but then it dropped the notion somewhere along the line. So we would speak about that a bit later. But I would allocate a couple of minutes to the discussion of this notion, constitutional national identity. Why are we speaking about the constitutional courts interfering into the dialogue with the national courts? The notion of national identity was introduced by the Lisbon Treaty on the European Community and the formation of the or creation of the European Community through the acceptance of those forms of national identity that can be found in political and constitutional structures of the member states. It's one of the recent studies, a fairly interesting one, by Horacio Dumbrava from Romania, and he presented this study at a session of the European Association. A fairly interesting study, as I said, about the conflict between the Romanian Constitutional Court and the EU Court of Justice. And it also elaborates on potential implications of this conflict. So the constitutional national identity is about the functional equivalency to the constitutional identity, and it is about the existence of various identities, constitutional identities of the member states. So if we say that the European community was founded by a special treaty, and that there is the legislation of the community, but at the same time there exists national constitution. So according to the Luxembourg courts, when the courts address issues of constitutional rights and freedoms, as in decision against Latvia. And we would be speaking about this principle of proportionality by the ECHR and the Luxembourg courts, because these are very serious matters. But according to the proportionality principle, the restrictions can be imposed only if they are necessary and respond to the public interest in the community, or are required to protect and promote human rights. In this charter, to the extent that it defines the fundamental rights that ensue from the notions common to all of the European member states, so they should be admitted. That's why constitutional courts were pointing to the circumstances that I mentioned before. So in 1983-84, the Federal Constitutional Court and the Italian Constitutional Court defined that, of course, that would be the competency and the jurisdiction of the EU Court of Justice to act within the legislation of the European Union. Of course, the EU Court of Justice does not repeal the national acts, even if they resolve that the national act runs counter to the acquis. And there was a case when the Commission tried to convince the court that the Commission's repealing a certain act acted lawfully. They said that they did not repeal the national acts. It's the competency of the National Constitutional Court, but they recommend the repeal of those acts because if they might run counter to the key in certain aspects, but there would be some aspects where they would be fully in line with the key. Returning to this triangle or triad that you mentioned, and you spoke about Delta Pikarna versus the Czech Republic, and that's a wonderful, very interesting and important case from the standpoint of the constitutional law and response of the constitutional law to, rather than the EU right, but the law of the ECHR. And it was about the anti-monopoly provisions of the Czech legislation. Delta Pikarna was a small company that was suspected of cartel collusion, and the police came to their premises without the search order because they've got this power, the Anti-Monopoly Committee, and Delta Pikarna complained to the national courts, and then it went to the Constitutional Court in order for a case from the Czech Republic to go to the ECHR. The Constitutional Court should consider it. The Constitutional Court received this complaint and it considered it, and it actually rendered a ruling. It rendered a ruling whereby it stated what? Can I correct what you are saying? Excuse my interference. The Constitutional Court back in 2010 rendered a ruling whereby the Constitutional Court was not to be considered by the Constitutional Court, was not acceptable or admissible because it the company asked the Constitutional Court to revise and repeal the decision of the national courts. So it went to Strasbourg, and Strasbourg said no.
До національних органів на виконання. І що зробив Конституційний суд Чехії?
Strasbourg said no, and it came back to Czech Republic. Czech court reviewed their resolution and said, sorry to say, but with your permission, I shall quote it because it's extremely interesting. What Constitutional Court ruled? It paid attention to motivation of European Court of Human Rights. I must note that legislation on Constitutional Court of Czech Republic was changed in 2014. This question actually should be discussed as regards amendments to Constitution and relevant law. Same way as for our national courts. If International Court recognize violation of human rights or rules on commitment, this is the basis for the review of decision of National Constitutional Court. The applicant sent an application to review his complaint from 2010. But Constitutional Court of Czech Republic and Constitutional Courts always protect national constitutional identity. And what for? They defend their constitutional identity. The scholars say when there are disputes between EU court or between European Union, Constitutional Court use this instrument as a shield to
умовно.
defend its
А
country,
якщо треба піти в атаку
figuratively.
і сказати,
But
що
if you
якийсь
want
документ,
to
директива
attack
ЄС,
and to say certain
ну,
document,
скажімо
EU
так,
directive
не зовсім відповідають національним
is
інтересам,
not in
це
line
використовується вже як меч для того,
with
щоб бути в
domestic
цій всій палявці
instrument very much. It is a sword
паячами. Але відверто
as
кажучи,
an instrument in this
взагалі
dispute.
загальна тенденція це
But the
дружнє
general trend
зворотнє
is
ставлення і розуміння.
friendly attitude and
До речі,
understanding.
давайте, да,
By the
дякую
way,
за це
Я
Thank you.
сказав, чим закінчилось?
Ні, не сказали, чим
Did
закінчилось.
I say what
але,
was the
перше
end?
питання, чим закінчилось?
No.
Можна я
So
скажу
the first
2
one,
секунди?
can I say
Дуже
just 2
цікаво.
seconds? What is very interesting? Constitutional Court came to conclusion that insufficient procedural safeguards for judicial supervision from the point of view of assessment of evidence and the volume of evidence that European Court referred to does not exist.
І вони були виправлені
They
попереднім
were corrected by the previous decision Constitutional Court. There was other decision Constitutional Court.
І тому
In 2017, there was previous decision from 2015. So,
було досягнуто в інший спосіб. І підстав для перегляду
protection of rights was achieved different way. No grounds to review the case. So Constitutional Court reviewed its position that it made. There was judgment of European Court. Then applicant applied again, Constitutional Court said everything's okay. If we imagine that this situation in Ukraine, there is decision on Constitutional Court based on constitutional complaint, then this case goes to Strasbourg, and Strasbourg Court rules that there is a violation. Although Constitutional Court of Ukraine ruled that this act was constitutional. This act, which later was appealed against in Strasbourg Court. There are cases when you can complain. In that case, what to do? There is a decision of Constitutional Court that is contrary to judgment of European Court, or judgment of European Court contrary to decision of Constitutional Court. This is the question rather for the future. Again, our discussion would be fruitless if we do not suggest anything for the future. In the future, we see a simple way out. In most countries, that in compliance with democratic standards, this is the basis for decisions of even Constitutional Court. But according to our Constitution, our law on Constitutional Court, it said they could not be appealed, they cannot be reviewed. When talking about constitutional complaint, using our national model, first constitutional complaint would be rejected, no proceeding opened. Second case, it would be opened, used interpretation. We always use case law of European Court of Human Rights, especially the remedies of interpretation of judgment. One can say that this is the achievement of the best legal thought. When talking about case law, reviewing constitutional complaint, the subject is the act, the law, which is used in the final court judgment, which is subjected to discussion. We always ask the Supreme Court what's their position. Especially in the recent years, Supreme Court chose the structure of its decision, which is in line with the structure of the judgment of European Court of Human Rights. Based on their criteria, it does not allow us to make a certain error. All the methods of interpretation are used. As soon as Supreme Court clearly, comprehensively uses case law of European Court of Human Rights, we have very little opportunities left to do something. In that case, we were supposed to say something new that European Court said. Alexander Vodyanikov remembers that, and Mykola Hlotovsky knows this, that is a debatable issue. Famous judgment 2016 on psychiatric assistance. Constitutional Court developed the concept as friendly attitude to international law. Many scholars criticize it, but we still use it. In this sentence, a friendly attitude to international law, EU law, is included there or not? Answering to your question, well, you see, all discussion will be under this motto. EU law, surely. But talking frankly, when we talk about the relevance of the study, in that case, we must have a look whether case law Constitutional Court was used, whether they use Court of Justice case law. We started using it, but in the preamble of our constitution, we got mentioning of our European and Euro-Atlantic Court, and the President and the Verkhovna Rada got the possibility to continue this course, promoting constitutional value of our country. From 2019, we use case law of European Court of Justice in decisions of Constitutional Court. Before we switch to a different part of our discussion, I have a question to Stanislav Ivanovich. Constitutional Court, apart from Mr. Gorodenko, didn't say whether this friendly attitude includes other acts. I hope the Constitutional Court will have this opportunity, but that does not exclude the possibility for Supreme Court to interpret this doctrine in order it can use it for further reference to case law of Luxembourg Court and the EU law. What's your opinion? You know, it's good or bad. Topic raised now, I'm trying to get included into discussion. For quite a long period of time, we didn't have a possibility to analyze the dispute or difference between the case law of the court. Many years were spent for that, and the result is there. How it will be with possible disputes with the Court of Justice case law, we are moving in this direction. We took commitments to take their case law into account as well. But if it comes to that, I agree with Viktor Horodovenko. This is the question for the future. Someday we shall reach the level of achievement, we shall define what to do in this case. But when analyzing case law, the Supreme Court in particular, of our Grand Chamber, the judgments that we made after European Court of Human Rights, certain things cause our concern, and we must work on that. At the events organized in 2024, when studying case law of European Court of Human Rights, judgments in cases versus Ukraine in 2023, there were quite many of them, 103, and 123 judgments when certain violations were stated. Mainly it's criminal law and procedure, but other jurisdictions as well. But when talking to judges, we have noticed this concerning trend. we are trying, if not to execute, but to adapt it. It is noted as an error, but we interpret it that it was done according to domestic legislation, so this thing should be resolved with local legislation, and this is quite a concerning trend. If we take such commitments, we must execute them, not look for the way how to do it for one side and for the other side. I don't want to have the same situation when we have three players in the field. Thank you. What is very important that even now, when we start Euro integration process, we can see that things will not be easy at all. But coming back to our European courts, when I mentioned that three centers of force in human rights protection system inevitably brings us to possible difference in the case law. This difference could be marginal, minor approaches, but it could be substantial. If we compare approaches of EU Court and Strasbourg Court, in particular issue, pertaining same cases in the spheres that they considered, we see diametrically different approaches. I mentioned only 4 cases where both European Court on Human Rights and Luxembourg Court on the same, more or less same circumstances, came to opposite conclusions after using opposite approaches. Number of such cases is getting more. The number is not very big, but they do exist. And when national courts faced with such circumstances, they must use case law of European Court of Human Rights and the legal stance of EU Court if this case is in the aspect of EU law. National courts face a question what to do, which case law to apply. Famous cases are Vita and the Veda pertaining to demonstration of religious symbols on the clothes. In both cases, company that dismissed an employee that wanted to assure neutrality of their company. Both courts ruled that it is a lawful objective. And then coming to standards, European Court of Human Rights used the standard of proportionality, but the European Court used other argument. The question of proportionality used by European Court.
Representative one of the peaks of this triangle on which the entire system of human rights protection and promotion leans. It's not a secret to you, and the number of such cases can only grow in the future, down the line. So what's the attitude on the part of the ECHR judges, and what are the tools for a dialogue between you and judges of the EU Court of Justice? Yeah, it takes only 2 hours to drive from one court to the other, doesn't it? Okay, so what are the elements of the dialogue that you believe should be necessary and appropriate for the 2 courts to avoid the repetition of such situations in the future? Yeah, this does work. Okay, good. Thank you. Good morning, ladies and gentlemen. I'm very glad to be in such a representative panel. It is a true honor for me to have a dialogue with Mr. Horodovenko, Mr. Kravchenko, and with you, Mr. Vodyanikov, on many occasions and for many reasons that are fairly obvious, the tools for a constructive dialogue between the two courts to take place in order for them to perform their functions properly and effectively is underway all the time. But I should start with more general considerations, I think, in order to address some of the ideas vented by both Mr. Kravchenko and Mr. Gorodovenko. So now speaking about the rock and the hard place, I don't think that these two courts are so dangerous for those trying to navigate the uncharted waters of the human rights. This navigation is possible and the waters aren't uncharted. And the legal regulation can be a bit different at the level of the EU acquis and the international law of human rights. The methodologies used by two courts are different, but that doesn't make the tasks of the international courts any more difficult, because thus they've got more room for maneuver. Then when we speak about navigation, we should understand the destination. Where are we heading? And what are we trying to achieve? There should be a certain aim, a goal, a destination. So unfortunately, there is a logic that is not focused only within the judiciary. According to this logic, the task of any public authority is to keep afloat instead of heading somewhere in a proactive and conscious way. Another aspect that keeps me worried in the context of this discussion is that this ocean or sea is multifaceted. It has many more dimensions than 3 dimensions, and there are some planes that never come close. Sometimes they overlap, sometimes they cross one another, and sometimes they just cast some shade on other planes. There are lots of various nuances here. And by and large, it is okay. It is normal because in our sphere of professional interest law, it's not the strict science with very strict limits and measurements. And sometimes the ECHR is criticized for using logical conclusions in a fairly furry case with not very specific circumstances. But specific circumstances of a certain case will stay in place. They do exist objectively, and even when situations are fairly close, like with that with demonstration of religious symbols, those two cases are not totally identical, because in the Lauzi case, the Grand Chamber also took into account Italian tradition without going as far as mentioning the notion of the constitutional identity. But in the SIS case, they referred to the French concept of cohabitation, which is so important for the French society. So in principle, those circumstances are different. another consideration that we should proceed from. So we are interested in all those cases from the standpoint of Ukraine. And this is a dimension that we should be conscious of. When we speak about any conflicts between any legal obligations or commitments or with a legal reality that goes beyond the national borders. So to me, we should proceed from a very pragmatic stance of the observer. I'm trying to use this actually perspective of the user or observer when humanitarian law and human rights law and some other laws impose a lot of commitments and obligations on the state, and sometimes they do not speak in the same voice, right? So this user's approach is sometimes very important, I think. So when we speak from the standpoint of Ukrainian user about potential conflicts between approaches of the EU Court of Justice and the ECHR, in this case, we should look at what we want and why we are obligated to do so. The European Convention on Human Rights is about our international commitments, and Mr. Kravchenko referred to that. Friendly attitude is a friendly attitude, but we have to honor our international commitments because this treaty was signed and ratified, thus imposing certain commitments on us. And I would like to reiterate yet again that if we have to learn the position of the ECHR about the friendly attitude, we should look at the case Gumboldt versus Germany, and that's the dialogue with Bundesgerichtshof. If it is a story with, or this is the case with the long story, and it is about the role of the court. It first emerged, say, in 1970s, I think. So it shows what it would look like from the standpoint of the international law, and the Grand Chamber refers to the decision of the permanent chamber or standing chamber of the International Justice of 1923, somewhere there, when those cases were addressed and resolved. Why is it important for us to learn the case law of the European Court of Human Rights? For one thing, we've got the Euro-Atlantic and European choice enshrined in the articles of our Constitution, and it affects various branches of power, the legislative, the executive, but not the judicial. But it's part of the preamble to the Constitution, so it covers everything. But frankly speaking, it is a fairly abstract idea as matters stand. It should be specified, it should be concretized, because it does not explain how the potential conflict can be resolved between certain approaches of the ECHR and the Luxembourg court. The association agreement with the EU is a different story. The membership negotiations also is a different case, and that's where it is part of the entire package of commitments, something that the state undertakes to abide by when it is striving to become a member of the EU. Another important consideration, and that will reflect to a great extent what both Mr. Kravchenko and Mr. Horodovenko mentioned, and it is varying nature of these two legal orders. The European Convention on Human Rights and protocols there to international treaties have got very serious support on the part of the Council of Europe, and the Committee of Ministers is one of the bodies in charge of enforcement of this convention, not only the court. So it's the Committee of Ministers and the court, but that's a political body of an international organization, and it is responsible for the execution of the ECHR judgments. And it wasn't that it just grabbed those powers. It was those powers were vested in it by the European Convention, and the court is guided by the consideration that it is part of the international law, and it is a document, one of the sources of international law, and the court should interpret and apply it. By so doing, it proceeds from the rules and interpretations that are offered by the international law. So it's no surprise that the ECHR judgments was always referred to the general interpretation rules from the Convention on International Treaties, and the idea of the living instrument, and all of those concepts and ideas around it proceed from the logic of the interpretation of the international treaty provisions. The EU Court of Justice, and in the presence of Professor Komarova, I feel a bit humble, but I should say that this is the legal order which is quite specific. It was born out of the international treaties. It was created by the international law, but is the supranational legal order, supranational but not supra-international law. So it is, or it exists in the legal space between the national legal order and international commitments. So, and we, Ukraine, want to join that union. We are willing to actually concede or yield a part of its sovereignty that would be delegated to the level of the EU. We want to be part of that union, not the Soviet Union, but the European Union. And thus, there should be an understanding of the hierarchy. It's not that some has higher standing than the other. It's not the question of a power game or hierarchy.
Але його треба максимально позбуватися.
Це просто hampers, however, but these are different functions, different levels. European Court of Human Rights, as Stanislav Ivanovich said, is not the fourth instance, but that depends how you look at it. This is not a classical fourth instance, but practical consequences are often similar. Court precedent is not a source of law in international law, but the consequences are the same. That's what we were taught many years ago, and it remains like that. Taking all that into account, the question arises, what should be the attitude of Ukraine? My answer is pragmatic, depending on what we want to achieve. There are many options of navigation. We have a lot of navigators. As regards particular conflict, what Strasbourg Court is doing to have friendly attitude and constructive relation with EU Court and vice versa. As regards friendly attitude, we are working on that tirelessly. There is a permanent dialogue between two courts. We regularly visit each other. It's not far away. You can go by train or bus, not a big distance to Luxembourg. We regularly communicate in closed format without censorship. One of the issues that follows from these exchanges when completing topic about interpretation, EU court has no need, has no grounds to interpret acts or laws of European Union according to Vienna Convention on International Agreement. It makes normal interpretation as a national court. Luxembourg court has same functions as domestic court judges. There is communication between two courts. After Reykjavik summit, heads of states of European Union, European Court, for the first time, got additional financing that allows them to hire more lawyers. Which lawyers European Court is hiring? We hire lawyers who are specialists on EU law. We need them in Strasbourg. One of the head of Secretariat of Court, very famous professor, Johan Calivert, who is simultaneously professor of EU law. He will retire to pension probably soon. We have pool of specialists. And it will become more serious. Talking about practical aspect, as Stanislav Ivanovich Andrassy mentioned yesterday, our website of EU case, knowledge sharing page, it's not in Ukrainian yet, but soon, thanks to our efforts, we shall get it quite promptly. If you enter this website, there are transversal topics, questions that are not connected with particular article of convention, but of general nature. There is European Court of Human Rights and EU law. How we use our case law and EU law. This is a considerable document. Considerable number of cases European Court of Human Rights linked with EU law. I can give many examples. Just occurred to me when at national level there is an application to EU court. Preliminary ruling is required. If national court rejects without proper argumentation, this is violation of Article 6 of European Convention of Human Rights. We oblige them to provide substantive answer to such
Це гарний приклад
requests. And
цієї
this is good example of this
конвергенції.
mutual support, convergence, etc.
Зі змістовної точки зору теж, я думаю, що
From the substantive point of view, if we have time, we shall discuss it. What we have? We have presumption of equal protection,
Є безспорська презумпція,
Crossword presumption,
і так далі, це, значить, проти Ірландії.
famous case versus Ireland. In conformity with that, in EU law, we have the minimal level of protection that European Convention of Human Rights provides, or higher than
Це
that.
послідовний підхід, тобто це
And this
презумпція,
is
так, це презумпція, яку можна спростувати, але вона
Consecutive
є
approach.
стартовою позицією для
This is a
для
starting
будь-якої
point
для
for
будь-якої подальшої
any
рефлексії. Не
further
будемо забувати, що
conversation.
для
Let's
Європейського
not forget
Союзу
that European Court,
ЄСПЛ, Європейська конвенція з
the
прав
Court of
людини,
Human
і
Rights,
Європейський
European
Союз
Convention
прав
of Human
людини,
Rights,
це є
Caselaw of European
частина,
Court
так
of
би
Human
мовити,
Rights is a
національних
part
конституційних традицій,
of
на яких
national
ґрунтується
constitutional
Європейський Союз.
traditions,
Тобто
which
це
constitute the
мінімальна
basis of
умова
European
взагалі
Union.
для
This is the
початку
minimal
розмови.
condition for starting conversation
Твоя
about
правова
accession to
традиція
EU.
європейською, в
If
тому
your
числі,
legal
вона визнає,
tradition is
що її
European,
створено
it
Міжнародною
recognizes
конвенцією з прав
what
людини, то тоді
was
ви про що говорити,
created
тоді
due to
про що
European
членство в
Convention
ЄС
of
вже
Human
немає,
Rights. You can start
І тому,
discussing your potential
безумовно,
membership
зараз
in
до
EU.
прагматично підходимо,
Coming
секундочку.
back to
Для
pragmatic
України
approach,
питання
for
вступу в
Ukraine,
ЄС починається із
the
виконання
question of
рішень
accession
ЄСПЛ,
to EU,
із
starting
вирішення
from
тих системних
execution of
проблем,
judgment, the
які
European Court of
визначені
Human
на
Rights,
практиці ЄСПЛ,
and
і
resolving
використання цієї
systemic
методики,
problems
з кількох там років.
that European
От, і
Court
останнє,
defined
вибачте,
in the
я
course of last 20 years.
вибачайте,
Fine
перебиваю,
sentence.
що є ще, як кажуть, elephant in the room.
There is also elephant in the room.
Є те, що, про що ми ще поки взагалі не говорили,
What we
але
have
воно
not
присутнє, воно
discussed
займає
yet,
дуже
but
багато
it's
місця.
there
Це
and takes quite a lot of
розмова
place.
про приєднання
The
Європейського
conversation
Союзу як
about
сторони до Європейської конвенції з прав людини,
accession
яка свого
of
часу
EU to European
не тільки
Convention of Human
просувалась
Rights.
далеко, але
On
потім
the
була
one hand,
ратифікована
it
Люксембургським
was
судом.
promoted too
І ми
far,
зараз
but
знову
then
рухаємося
Luxembourg
кудись
Court blocked
далеко,
it. Now it moved
і
again,
чекаємо на те,
and
що
we are looking forward what will
якщо
happen.
це відбудеться,
If that does happen,
це може полегшити життя
that
до
can
певної міри, в тому
facilitate
сенсі, що
life to some
порозуміти там,
extent.
як ми
In
взаємодіємо,
the
як
meaning,
це
how we
унормовано,
interact, to regulate it somehow
конкретно, так як ми любимо
more
говорити.
specifically, the way
Максимально
we
формально.
like it,
Але
maximum
якщо цього не
formally.
станеться,
But if that doesn't
взаємне
happen,
співіснування і
mutual
діалог,
coexistence and
дружба,
dialogue and friendship,
ну така вона, дружба, як ви знаєте, вона різна
no,
буває.
friendship
Але
could be
вона
different, you
все
know,
одно є,
but
вони
it
продовжаться.
does exist,
Дякую.
and these talks will continue.
Що з вами завжди приємно
Mikola Mikolaevich, it's always a pleasure to conduct a dialogue with you. You allow provocative questions, and I will use this opportunity. It's true. Interaction between two centers is very complicated. If we remember history, such difference, drastic differences were quite numerous. Approach in Hirsch case in Luxembourg and approach against Germany in Strasbourg. Whether the right to private life covers office room. Luxembourg said no. 4 years later, Strasbourg says yes. Then was Cantoni versus France case in 1994, where Strasbourg court said quite confidently, despite the fact that legislation is implementation of EU law, anyway, it is under control of Strasbourg court. Later, there was this Bosphorus the case where presumptions was established, and somehow it looks like as regards Lisbon Agreement, Charter Fundamental Rights became a part of the primary founding agreement of EU. Strasbourg was ready to review its right to control EU law. After Lisbon, it became clear that the situation is changing. And Luxembourg court ruled twice. No, EU will not accede to convention. We have a charter, etc. And situation has changed. You mentioned that you hire experts on EU law. That resigns me kind of swings.
І таку певну, чи не здається вам, що це все питання полягає
Doesn't it
в
seem to you that the question is
пошуки, хто головний в Європі з
Search
прав людини?
who is major
Ну, чудові
body
питання.
guarding human rights in
Якраз
you?
те, що треба.
Very good, provocative question. That's what we
Що
need.
стосується-
As
поясніть
regards,
точно.
I start from
Головне
the end.
оцим не займатися.
The
Тобто не
main
намагатися-
thing
не намагатися
is
доводити,
not to do it,
хто
not to
головний.
get
Я вам
engaged
чесно скажу,
into
як
trying to prove who is
у
the major
практичному
institution. As for
вимірі
me, in practical
для
sense,
кожного окремого заявника, для кожного
each
окремого суб'єкта
individual applicant,
головним
each subject,
є
the main
і
thing
буде остаточне
is
рішення
and will
Національного
always
суду.
be the final
Національного
judgment
суду.
of
Не
national
суду
court.
ЄС, не
Not
суду
EU
Європейського,
court,
національного
not
суду.
Strasbourg court, but national court.
Тепер
Now,
є дійсно
it's
сфери,
true,
в яких
there are spheres
практика розходиться.
in
Ті,
which
які ви навели,
case
це
law, the
більше,
two
як
courts
для мене,
differ.
історичні
Cases that you
приклади.
mentioned,
Є
they're more
сфери, де
historical, but
практика
there are
розходиться
spheres
згодні
where
з
case
зараз.
law
Наприклад,
differs
виконання європейського
now.
ордеру на арешт,
Uh,
можливі перешкоди до цього, так?
execution
Або
of
що є
European arrest
е,
warrant, possible
стандарт,
obstacles.
який
There is a
відстоюється
standard
судом в Страсбурзі,
protected
який
by
полягає в
Strasbourg
тому, що
court.
крім загальної
That means that apart
загальної
from
оцінки ситуації в
general
державі, яка
assessment of
запитує
situation in the state that is requesting extradition, you must assess individual situation of a person which is requested.
Нинішній підхід в Люксембурзі полягає в тому, що
Current
достатньо
approach
загальної
in
оцінки.
Luxembourg is a general
Тобто
assessment
світ,
is enough.
менш дружній до
It's
прав
less
людини,
friendly
якщо можна
towards
так
human
сказати.
rights, if I can
Наприклад,
put it like
один
that.
із випадків. Хоча, зрештою, їх не так і
This
багато,
is one of
якщо подивитися
examples,
всю
although
сферу, тобто
these
це
cases are not
теж
numerous.
всі
If
можливості
you
знайти.
look at all possible
Питання не в тому,
interactions, the
щоби,
question is not
уніфікувати ці системи.
to
Питання не в тому,
unify this
щоби
system. The
домогтися, щоб
question
вони
is not to
однаково
achieve
відповідали
situation
на
when
питання.
they
Питання
answer
в тому, щоб вони були
questions same way
сумісні.
always.
Це
The
різні,
issue
все
is
ж
that
таки
they
різні
must be
різні
compatible,
і вони,
and
в
these
принципі,
tasks are quite
досягаються.
different, and they could be achieved.
Концепція така приблизно тут,
The
що
concept is such.
ну, от мовою судовою нашою, тобто це
When talking in judicial
Бачите,
language,
я терпіти не можу, коли людина
Sorry.
посиділа за кордоном, приїздить і починає іноземними
what I
піснями
hate
говорити.
when a
Це
person
просто, що
worked
це не стало.
abroad
Я
and
зараз
coming
сам
back
самий
using
приклад
foreign
український.
expressions,
Ultimate benchmark, та? Тобто,
ultimate
що
benchmark, because I'm using English
останній
expressions all
рівень
the
оцінки,
time.
як би мовити, так?
The final level of assessment
Який є, це зрештою практика Європейського суду з прав людини.
is the
І
case law of
її,
European
власне,
Court of
варто
Human Rights.
враховувати,
It
як
should
на
be
мене.
taken into
Коли
account,
вирішується питання,
as for
пов'язане
me,
з правами
when
людини. Нещодавно була
deciding on cases
дуже
connected
гарна
with
справа,
human
яка,
rights.
як на мене,
Recently, there was a very
свідчить
nice
про
case
наші
that
взаємини і можливості
is
для
a
знаходження
positive
спільної
sign
позиції.
of
Справа
our
пов'язана із
relation. Case
особливим
connected
порядком
with personal
ритуального вбивства
special
для релігійних
procedure
цілей.
for
Відомі справи
ritual murder of animals for religious
Execution
person.
van de Moslims van België.
Executive van the Muslim van België.
Там була відповідна практика до цього в суді ЄС. І, по суті, там вищі
There
стандарти.
was such practice in the EU court, and the highest Belgian standard. It's not about the animals' rights, or not quite about animals' rights, but about the morality of the society as it perceives itself. The ban on killing animals without the previous anesthesia, for example, something like this. So the chamber of the ECHR unanimously supported this Belgian standard and the right of the Belgian courts to have higher standards. And that fits very well into the case law of the EU court. that made very unhappy two religious communities in Belgium, the Arab and the Jewish one. But the panel of the Grand Chamber did not accept it or made it admissible. Another thing, again, when it comes to power games, the EU law is an autonomous legal system. It's an autonomous legal system. It's the branch of the European law, but it is supranational. But referring to my first premise on the user's approach, judges and prosecutors in any country are not autonomous, and they have to cope with all of these things. So it is better to agree on the following. The European Convention on Human Rights remains the minimum standard. If the EU member states want to raise their standard, it's up to them. Thank you. Yes, indeed, Luxembourg court does a lot. And an interesting trend can be traced if we look at the practice of referring by this court to the ECHR case law. And it is about the autonomy or search for autonomy. On the one hand, in Luxembourg, in the sphere of human rights. And some authors even speak about Chartism as a phenomenon observable in Luxembourg. The attempt to establish the Charter as the basic document in the EU member states and convention, of course, it exists, but we, have the Charter. It's not the basic document to us. And if we compared with Österreichische Landfond, which is all fraught with the referrals to the ECHR case law, but after the Lisbon Treaty, it doesn't refer to it at all, even though the circumstances are similar. So this trend is very powerful and interesting at the same time, not in that Luxembourg doesn't like these cases. It would be oversimplification to say so. But because there is a need to establish the autonomy of the European law, including vis-à-vis the European Convention on Human Rights and the Strasbourg Court. And we will have to live with it once we are the EU member state. And approaches to this issue by the national courts is very important because we are used to thinking that there are very esteemed courts in Europe and they will protect our rights. If we need that, they are very wise. They're eminent legal persons that know all. But indeed, the entire system is built or construed within this triangle with no top corner where all of the sides are equal, where the national courts play a leading role. And yesterday, Mr. Gnatovsky spoke about subsidiarity as a mechanism through which the entire triangle operates. Any questions from the audience to our esteemed speakers?
The
question was quite correct, but if I may comment on it just for a couple of seconds, perhaps half jokingly, but every joke is just partly a joke. We've spoken about the differences, but I would like to underscore something that brings them together. And I'm thankful here to Judge Gnatovsky for the definition in this very case. The colleagues of mine that are present here know very well that when we consider a difficult, quote unquote, case, we want to keep within the case law of the ECHR, but then we understand that perhaps other courts' practices should also be looked into. And now we see that similar processes are underway in the EU Court of Justice, shows that we are keeping apace with the recent tendencies. Good morning, dear colleagues. I am Professor Komarova, mentioned several times. Thank you very much for that. And I'm a person who is extremely happy that this discussion is taking place right now. I've been studying the case law of the Luxembourg Court since 1995, when it wasn't mainstream. And finally, we are speaking about it as such fora. And back in 2010, a judge from a Transcarpathian region was disciplined for referring to the practice of or the case law of the Luxembourg Court. And now judges are very cautious when deciding to refer to this case law. The Constitutional Court is braver in referring to that case law, which is broad and extensive. But within this discussion, I would like to make several comments. I think they are important. For one thing, the Convention and the Charter were adopted for different goals. The Convention imposes certain commitments on the participating states, and these states can be made liable for non-abidance by it. But the Charter established rules for the Union rather than the member states. So we should understand there's a list of issues that are delegated to the competency of the EU, and the acts are adopted there, and then the Charter will apply to those acts. And there are issues that still remain within the national competencies and purview, and it's where the Convention would step in and guide the regulation of legal relations. It doesn't mean, of course, that there would be no overlaps, because the Charter can also apply to the activities of the member states when they implement the instructions of the European Union. And there might be diversions here. But Judge Gnatowski is right in that the Charter reads very clearly and explicitly that the Charter should be interpreted in the light of the Convention, and the EU can give the highest standard or set the highest standard of case law. And the Convention is a source for the interpretation of human rights for all EU member states. And what Justice Gorodevenko says, that the Charter respects the constitutional tradition of the member states, and the Charter should be interpreted in line with the constitutional tradition of the member states. And these are the three premises that we should take into account while we analyze the relations between the Charter and the Convention. It's good that we are discussing the Charter now, even though it's not a source of law to us. It can only be a source of inspiration. But when we do become the EU member state, it will be too late to study it. It will be more topical, perhaps, not too late, because the end of your comment sounded too tragic to my liking. Yes, indeed. Any text is implemented through the practice of application or enforcement, and the practice can change
підходи можуть бути
And approaches
різними в залежності
could be different
ситуації,
depending
і в
on
кожній
the
конкретній справі, да,
circumstances,
специфіка
and in each
має бути.
specific
Да,
case,
недаремно,
the circumstances
прав,
could be
і я дякую,
different.
що наші учасники панелі
I would
погодилися
like to
з
thank
алюзією
the
на
panelists to
міфологію. Да, чому? Тому
work
що євангельська
along the
міфологія,
lines
вона
of this
багато
Greek
джерела
mythology
в своїй
and
змісті.
allusions
Ми з вами,
therein,
коли
because it
побачимо
has several
цю
layers to
євангельську,
it.
ми з вами,
When we
у нас
see
яка перша асоціація?
this
Чому
rock and hard place, or rather
або
Scylla
вибірочку
and the
із
Charybdis,
двох зол на
we
гірших,
see
да?
two
Це
evils, and we
правильно, це
think which of them
інтерпретація,
is
це
the
конотація
lesser.
вже Еразма
Yeah,
Роттердамського
there is
історика,
a
да,
connotation,
якого
but Erasmus from Rotterdam
вона
and
історія.
other
Да.
thinkers and philosophers, but the Greeks themselves interpreted this allusion in a different way. And
Змістом цієї алюзії було
the
уникнути
main point was to avoid and evade a threat. When they spoke about Scylla and the Charybdis, they thought of how to avoid the risk, how to avoid a danger, but our esteemed panelists saw Scylla and the Charybdis as two threats, and Ukraine has to somehow navigate in between the two. But this very ancient Greek mythology mentions these two rocks in several works in the Aeneid, then the Iliad. And there's the third source about the Argo sailors who managed to navigate through this strait thanks to Achilles' mother, and they navigated through it with no losses at all. And I'm sure that Europe and Ukraine, as part of Europe, would manage to do the same. And we, within the Council of Europe and the European Union, would be following this Thucydides route and would not get into this danger. Thank you very much. I would like to thank our esteemed panelists. I would like to thank the audience for their very active engagement. And it's up to us to thank the moderator for a very good moderation. Thank you very much. I would like to thank our esteemed panelists. Your applause. Thank you. Thank you for a most interesting discussion, for your expert opinions, and for the discussion of such topical matters. Now I would announce our next session. It is dedicated to the compensation for damage caused by war of aggression against Ukraine. And I would now give the floor to Vitaly Chernenky, Deputy Dean of the Faculty of Law or Department of Law, Ivan Franko, National University of Lviv. Thank you very much for your attention. Good morning. Good morning, dear participants. I'm Vitaly Chernenko. I'm Deputy Dean of the Law Department in National Ivan Franko University of Lviv. And if I could ask you to bear with me for a couple of seconds, we need to wait.
Тож, я думаю, що ми можемо розпочинати. Я
I
сподіваюся, що
think
ви
we can
зможете
start.
подивитись на мене. Я тут.
I hope you can see me. I'm here.
У нас ця панель достатньо важлива в
This
ключі
panel is quite important for us
перед Україною
in the light of challenges that Ukraine will face soon. Олександр Водяніков plunged you into Greek mythology issues. I also have examples like that, but I rather not do it. I will explain you how next panel discussion on compensation of damage will be conducted. It will consist of two parts. First part will be a keynote speech. Sergei Pogrebny, judge of the Grand Chamber of the Supreme Court. It will give the tone to our discussion since Sergei Pogrebny make a general review of case law, case law Grand Chamber of Supreme Court on that. After that, after implementing your right for coffee break, you will have possibility to drink your coffee and take some cakes. Apart from inviting speaker, I want to make several announcements. Several comments. Compensation for damage is one of the most acute questions that practical lawyers and judges face. There are a number of challenges that we face in the light of the law adapted. The law on compensation for damage caused by war. Immovable property was taken in 2022. That means that all those victims that suffered in 22 and later is not covered. It doesn't cover all those who were victims before that law was adopted. And these challenges could be overcome. I hope now we shall see the presentation.
З'явиться презентація за кілька секунд, і я передам слово Сергію Олексійовичу. Я хочу
Сергій
увагу, що дуже важливо,
Погребний.
щоб ми зараз уважно підійшли до цієї частинки
Very important
нашої
is that we have
оскільки вона розрахована на 25
attentive
хвилин,
approach.
потім буде
It
можливість
will last
запитань.
25 minutes that you will have possibility to ask questions. Our panel discussion
Плануємо, що вона буде дуже пунктуальною. Ми хочемо показати, як
it will
воно
be
може і має бути.
very specific.
Тому я
We
передаю
must
слово Сергію
explain the way it
Олексійовичу.
maybe and
У нас
it
буде
should be.
орієнтовно 5 хвилин на питання-відповіді.
5
Потім
minutes questions
перерва,
and
і ми
answers. In the
перейдемо
end,
після
then
перерви
the
до
break, and
певної,
after break we shall come back to
загального обговорення. Вже
general
пізніше я
discussion.
представлю
Later
учасників.
I will
Сергій Олексійович,
introduce
будь
other
ласка,
speakers. So,
поруч з вами.
Mr. Pogrebny, the floor is yours.
Добрий день.
Good afternoon.
Дякую. Дуже приємно,
Thank you.
незважаючи на
My
оголошення
pleasure.
перерви, дуже приємно
Despite the
бачити
fact
всіх,
that
хто
break
залишився,
is announced,
надали перевагу моїй доповіді.
I
на
see
Михайлу. Я,
that
чесно кажучи,
you are all here,
єврофраз.
most of you here. You chose me, not coffee. As for me, I would rather choose coffee. My mission is hard today. On the one hand, I must tell you about case law of Supreme Court, Grand Chamber and Cassation Courts. On the other hand, someone while reviewing the case law, I must express my consideration, how I see this problem. Let us organize our work in such a way. If you have questions, you may provide them in written format. After presentation, I will be pleased to answer your question or not answer your question, the case as it may be. My topic is review of the national case law for compensation for damage caused by war. Now I come to serious matters. I want to thank our armed forces of Ukraine that fulfill the main functions in this state, giving us possibility to get together and do our job that we love and which is also very important. I see that the audience is very, very professional, and I will speak about simple things and about difficult things.
Безумовно, судова практика,
Of
вона
course,
таке
practice,
надзвичайно
case law,
динамічне явище,
it's a very
яке
dynamic
намагається
phenomenon
відтворювати потреби
that
суспільства.
try
Судова
to
практика віддзеркалює ті
recreate
потреби,
needs
які
of
є вкрай
society.
нагальними
And
в той
this
чи інший
case law
період розвитку
reflects the
держави.
needs
І ви бачите,
of the
що за
state
останні майже
at
3
a
роки
certain
судова
moment
практика
of history. In the last 3
змінилася
years, case
кардинально.
law has changed dramatically.
Якщо говорити про
When
практику
talking
Верховного
about
суду
case law of
дотичну
Supreme
до
Court
вирішення питання про відшкодування
in
збитків,
relation to
я
compensation
хотів
for
чином
damage
донести
caused by
це
war,
до вашої уваги,
I
щоб
was
вам було
thinking
сприйнятно.
how to present
Я
it to you in a
розділив
way that it is acceptable. I have
ці
divided
питання
these legal
на
matters
4 категорії.
into 4 categories.
Ну, до першої категорії можна віднести
You can relate to first category claims of Ukrainians reviewed by Ukrainian court with claims to aggressor country to compensate for damage. Second group is claims to Ukrainian state, compensation for damage caused by armed aggression. Third group of cases that appeared in the recent 3 years claims to employer over claimant during implementation of working duties or its descendant caused by aggression. And third group, compensation for value of property confiscated for needs of war. I made a brief review of decision of courts, and I think I can give it to organizers that you have possibility to know it.
Перша категорія
The first group of cases,
позовів. Безумовно, це позови до
Or
країни-агресора з вимогою
claims
про
to
відшкодування
aggressor
шкоди, завданої
country,
збройної агресії.
demanding compensation for damage caused by Russian aggression.
Відзначити
Here I must
три,
note
основні постанови.
3
Перша це
main
постанова касаційного цивільного суду
resolutions
22
of a cassation
друга
court
від
from
травня 22 року.
April 2022, second is from May 2022, and third, resolution of Grand Chamber pertaining to overcoming jurisdictional immunity of aggressor country.
Я вже неодноразово виступаю, і конотація така, що я
I am speaking not for first time, and my connotation is such as if I'm justifying the position of Supreme Court. But overcoming jurisdictional immunity of aggressor country was well justified in conditions of April 2022, because there was a request from society, from the states, and we were and continue being in the status of war. There was a need to continue this war in the sphere of jurisprudence. Supreme Court could not stand aside of the problems that society and country faced and provide response. What were the main ideas of the resolution of Cassation Civil Court?
Перемкніть наступний слайд. О, дякую.
Next slide.
Ну, перше, це застосування деліктного винятку.
First, yes, use of delinquent exception that could be used to any dispute arose in the territory of Ukraine from its citizen against a foreign state, in
Я звертаю вашу
particular
увагу,
with aggressor country.
ця
I want to
позиція,
draw
ця ідея
attention
щодо
that this
деліктного
position,
винятку,
this
вона
idea
не
about
носить
delict
характеру
exception
суто суб'єктивного.
is
Тобто, що
not
це
of
стосовно винятково
subjected
до однієї країни.
nature in
Вона застосовна
relation to one
будь-якої іноземної
country.
країни, яка вчинила збройну
It
агресію
pertains to any
проти
other
іншої
country
держави.
that
Тобто цей
committed
висновок
aggression
він є
against
універсальним.
our country. This
Друга
conclusion is
ідея.
universal.
Це
Second
ідея
idea,
про те, що вчинення акта збройної агресії не є реалізацією
committing an
суверенного
act of
права,
armed
чи
aggression is
порушення
not realization of
європейського
sovereign
суверенітет та
rights, but
територіальної
rather
цілісності.
violation of commitment to
Ну, і,
respect sovereignty
третя
and territorial
ідея
integrity.
полягає в тому, що це є
Third idea,
реалізація права
it
України
is realization
на
of right of Ukraine for self-defense.
Я побуду клікером, будь ласка, наступний слайд.
Чудово.
Next slide.
Ідеї, які закладені були в
The
постанові
ideas
Конституційного цивільного суду від
included
квітня
in
22
resolution of
року були далі
Cassation Civil Court
продовжені
from
в
April
постанові від
22
травня
were
22 року.
continued in same resolution in May 22.
Основна ідея полягає в тому, що
What was the
суд
main
український
idea?
визначив, що
Ukrainian
звернення
court
позивача
ruled
до
that
саме українського суду є єдино
claim
доступним способом
of
і
an
засобом
applicant to
захисту
Ukrainian
права.
court is the
Позбавлення якого
only
означатиме позбавлення
accessible
такого права
remedy to
взагалі,
protect the right.
суперечило б, самій суті такого права.
Depriving that applicant of this
Далі,
right would be contrary to the
ідея
substance of the right.
непропорційність
Then Supreme
мети
Court
забезпечення
expressed the idea
юрисдикційного
and
імунітету,
unproportionality of ensuring jurisdictional immunity if Ukrainian court abides by this idea.
1.3. Розвиваючи
1.3.
ідеї в липні 22
When
року,
developing
це
this
справа не про
idea in
відшкодування,
July
справа про
23,
інше, але
it's
вона
not about
має
compensation,
значення для розглядуваної нами
but it
теми
is
в тому
important
контексті,
for discussing this
що
topic
Верховний суд
in the context
обґрунтував,
that Supreme
що
Court
юридична особа, яка на
or
території
legal
країни-агресора
entity
має право представляти
that in the territory of
державу,
aggressor
звернулася до
country is
українського суду
entitled
так
to
само,
represent
визнавши
the
юрисдикцію
country,
України щодо вирішення
addressed
законних
Ukrainian
спорів на
court,
території
recognizing
української
jurisdiction of Ukrainian court
Далі.
in the territory.
Четверта постанова – це
Fourth
червень
resolution,
22 року.
June
Це
2020.
одна із перших справ, яка
One of the
дійшла в
first
суд касаційної
cases that
інстанції,
reached
і
cassation
визначає
court,
відшкодування шкоди.
case on compensation of
Зазвичай
damage.
дуже мало цих спорів доходять до третьої інстанції,
Few
враховуючи, що
disputes
відповідальна
reach third
країна-агресора
instance
у нас не бере
because
участь у цих процедурах
applicant from
справ.
aggressor country does not
Перед
take
Верховним
part
судом
in
постало надзвичайно складне
hearing such
питання.
cases. Supreme Court faced a very
Як
difficult issue.
переглянути це
How
рішення
to review this decision
винятково в тій частині доводів,
exceptionally
які
in
наведені,
the
бо
part
незадоволений позивач звернувся з касаційним
mentioned by the
Це
applicant because it's the
найперше
unsatisfied
перебування
applicant
судом
file
верховного
and appeal
принципа,
complaint. It's not first time the Supreme Court
забудування
formulated
теорії
principle
але
not
у цьому
return
рішенні,
to the worst
одне із перших
previous
надзвичайно чітко
status.
було
But
сформульовано
first
цей
time it
принцип.
was
Ви
clearly
знаєте про те, що
it was
принцип
clear formulation
заборони
of this principle.
поворотних
Principle
перешкод,
of
він
return to the worst
реалізований в межах
is
кримінального
more
процесуального законодавства.
realized in criminal
Цивільний
procedure
процесуальний
legislation.
кодекс та
Civil
царський процесуальний кодекс не містять, ніби
and
не містять такої заборони. Відповідно,
economic
Верховний суд мав
commercial codes
керуватися
allegedly do not contain it,
загальними якимись принципами.
and Supreme Court
Але,
could be
тим не
used
менше,
general
в межах, в тому
principles.
числі
Nevertheless,
цивільної справи, було
within
зроблено висновок про те, що
consideration of the
розглядається
civil
справа
case,
на стадії
conclusion was
касаційного
made
розгляду неможливо
when
визнати
overseeing
як загальне
it
правило,
at cassation level,
формуючи
you
ствердження.
cannot worsen the
І
condition
цей
of the
погляд,
claimant.
цей принцип ґрунтується на
So
тому,
this
що
principle
суд
leans
касаційної
on the
інстанції
following. The
обмежений,
cassation court
зазвичай
is
обмежений
usually
доводами і вимогами
limited with the reasoning and requirements by the complainants according to Article 400 of the Code of Civil Procedure of Ukraine. Another category of cases would include
Друга категорія спорів, вони продовжують існувати в практиці судів першої
the following cases that still exist in the trial courts, the courts of appeal and cassation. And that is about the compensation of damage caused by the armed aggression. I will refer to the resolution of the Grand Chamber taken in May 2022, and it was then detailed by other resolutions. The 2022 resolution of the Grand Chamber continues and develops the principles and ideas of the previous resolutions, whereby the Ukrainian state cannot be liable for the failure to fulfill the negative obligations. And we are speaking about the resolution of 2018, whereby the Grand Chamber decided that the applicant is entitled to the compensation because the state fails to fulfill its positive obligations. And the obligation is that the state should have provided certain administrative mechanisms for compensation of the damage. But in 2022, those mechanisms were introduced, so there were no grounds for the compensation of the damage caused by the armed aggression. Right, next slide, please. You can see certain excerpts from the 2022 resolution of the Grand Chamber. I would not be reading all of those for want of time. Slide 12, if I may. Two more. Okay, three more. Good. The resolution of the Cassation Civil Court of September 2024, the obligation of the state vis-a-vis respect and protection of human rights do not disappear in the wartime. And then the ministry has undertaken the positive material obligation to define the measures of the rights to compensation for the deaths of civilians. Its non-performance or poor performance should be established by courts. And then there's the third category. Next slide, please. This is a category of cases that were filed with the Cassation Civil Court, and they are complaints against the employer of a person who was killed by a mine hit by him. I would like to tell you more about this case story. The employee who hit the mine with the car worked for a forestry, and as far as I understand, his wife claimed a compensation of a material damage because he worked for the critical infrastructure facility and he was killed as a result of the armed aggression by the Russian Federation against Ukraine. So it is also about the labor rights of this individual. I encourage you to read this text in detail because in this case, the Supreme Court proceeded from all of the circumstances of this case, about this casus. There was no fault, no guilt, no violation of the law by the employer, so there are no grounds for the compensation of the material damage caused by the death of this employee. And later I will be speaking about my personal attitude. I think that this resolution promotes the idea from which the following conclusion can be drawn. If certain illegal acts by the employer could be established, then perhaps we could be discussing the opportunity for the compensation of the damage by the employer. But another specific feature of this case is that forestries are facilities of critical infrastructure, and there is special law that provides for the right to one-time monetary assistance in the case of damage caused to the employees of critical infrastructure facilities. Then, next slide, please. The fourth category of cases, and it is not about the compensation of damage in the meaning of Article 82 of the Civil Code, but it is still about the compensation. Next slide, please. Next. Yet this one, thank you. So I couldn't omit this category of claims that we have in our chamber. That would be the resolution of the Grand Chamber of September 2023, then another one by the Supreme Court of February 2024, and the Grand Chamber resolution of the 23rd of October 2024. Now, commenting on the latter, I would say that the Supreme Court to turn down this case, but the resolution has not been entered into the unified registry. Very soon it will be there. And if we could make certain conclusions now. First, the resolutions of the Supreme Court of 2022 about the overcoming of absolute immunity were absolutely justified. They were in line with the imminent and immediate need of the people and the state. One of the preconditions for the Supreme Court to render those rulings or resolutions was a conclusion whereby there was no realistic and understandable mechanism for the compensation of that damage. The situation has changed over time, and today the Ukrainian society and the Ukrainian state pin a lot of hopes on the international mechanisms of compensating the damage and reparations. You know that the International Registry of Damage has been put in place, and it is an effective mechanism, particularly when stage 2 starts, when the actual payment of the compensation start, and the national courts would be playing a subsidiary role. In 2022, the Supreme Court took a first step without considering the case on merits when it came to the claim against the aggressor state, but it enabled the national courts to consider this category of claims. And in 2022, then in 2023 and 2024, it has been up to the legislature to implement the approach of the Supreme Court into the legislation when it comes to the overcome of the jurisdiction immunity. A special law should have been adopted to allow us to consider this category of claims. Since our major goal is to make sure that relevant decisions of national courts would be recognized in the civilized jurisdictions, this is a need. Thank you very much. It is a most important review of the cases in this domain. Any questions to esteemed Justice Pogrebny? It is essential for us to understand the details of such consideration. Right, there are questions I can see. Raise hands. Good. Good morning, esteemed Justice Pogrebny. Why do you think the sense of Article 6 of the Convention, I understand that we cannot notify the aggressor state about the violated rights if we model the situation for the future. When such cases have inflated compensation amounts, how then will we be referring to the fact that the aggressor state did not participate in these processes? Could you please formulate your question? The aggressor state, as a result of its aggressive actions and unwillingness to abide by the convention, was not notified about this claim, and they could not object to the sum indicated in the claim. So it's about the participation of the aggressor state. In such situation, when we speak about the quality of the court decision, we should give priority to the quality when it comes to this dilemma of quality versus timelines. And I think that even though the cases are considered in absentia, it does not deprive us of the ability to critically weigh all of the documents. We have to critically assess all of the evidence in the case. And if we recognize unfounded demands or claims as well-grounded, we would undermine the authority of our own courts, won't we? So the Supreme Court stated back in 2022 that the Ukrainian courts can apply the conventions that have not yet been ratified this case to any country, including the aggressor state. And that was one answer given by the Supreme Court. And I see that the legislator should have defined the specificities of considering such cases, the entire category of cases, vis-a-vis all foreign legal entities and all foreign states in absentia, so that the process is adversarial enough. Thank you.
Alexander.
Я дещо переформулюю це питання, яке було
I
поставлене
shall
шановним суддею.
reformulate same question.
Думав, будете мені допомагати.
I thought you will help me. No,
Питання не в тому,
I
що
will reformulate question asked by
Чернівці
Chernyvtsi colleague.
не буде застосовуватися. Давайте
Convention will
Тому
not
що
apply
гарантує
to
права
this group of cases.
людям, а не
It
державі.
guarantees
Це по-перше.
rights of
Тут постає
people,
друге
not
питання, дуже
states.
важливе. Виконання.
But other important
Виконання
question
рішень про
arises.
виконання.
Execution
І
of
це
judgments
відкриває
abroad.
цей весь букет
And
питань,
here
пов'язаних
we are
з
acquiring the
повідомленням,
huge bouquet of
з розумністю,
questions.
обґрунтованістю збитків,
Notification with
з
indication and
повідомленням,
calculation of
просто
damages.
ще
As regards
Franko,
notification,
наприклад, розкаже,
Sergey
тому що
can
від
tell
держави
you
не
in more detail.
вимагається
It's
підтвердження,
not required from the state
що відповідач був
to
повідомлений.
confirm that respondent was informed. There is no requirement. What is required is all was done that Russian Federation received its notification. In this aspect, it is clear, in general, in case there is a request to enforce, you can prove that in this proceeding of Ukrainian court as a party made all possible to notify using existing mechanisms of ad hoc notification.
Проблема в тому, що рішення
What is the
22
problem?
року,
That decision of
випадку
2022,
вийшов за межі.
Ukraine Supreme Court exceeded the limits because you applied conventions that didn't come into effect and you used them as the customs, as distinct from criminal code. Other codes does not give the right to Ukrainian court to use any customs. It's possible only in the criminal procedure. This is a direct action. That can create a problem. In the part of recognition and enforcement of judgment of the court abroad. And this is the challenge for Supreme Court. If not correct, but to fine-tune the position, because who will use this position? It's not Ukrainian, but foreign judges for whom, to which Ukrainian applicants will come asking for enforcement. This is my comment, to separate these two issues, convention and enforcement, but recognition and enforcement. I will not argue, but I agree fully with Alexander. To enforce judgment of European Court in the territory of Ukraine is not possible. And Supreme Court is fulfilling one important mission. It is considering special group of disputes, recognition and enforcement in the territory of Ukraine of foreign judgments. And our court knows it. And there is so-called a caoutchouc norm, a caoutchouc category, public order. When Supreme Court get judgment of Supreme Court, it takes public order from this unknown category, deciding whether this judgment of foreign court violates Ukrainian public order. No. And judgments of Ukrainian public court will come for enforcement abroad, and foreign court will look to what extent judgment of Ukrainian court violates public order. Belgium, Luxembourg, France, Britain, and it will say, oh, these are fundamental principles of our civil process of violation. We shall not give permission. What I'm leading to, this was make
Тут
our
робота, яку виконує
decisions
не тільки
such
українська
high
система
quality,
і
and
законодавці, ця робота
that
немає
involves
депутатів
the work
сьогодні,
not
це
only
Верховна
judiciary
робота
but
законодавців.
legislative. We don't have a lot
От ця
members
робота
of
має бути
parliament here.
настільки
Legislator
якісною, щоб
didn't fulfill his
після
job.
рішення українського
It,
суду
this
судді
judgment
та
must be of such high
після
quality.
виконання цього
After
рішення
seeing
на
it,
її території.
Belgium court will allow enforce the judgment in its territory. And then I put 3 dots.
Дякую. В мене є,
Thank you.
бачу. В мене є
I
таке
see.
прохання, ще одна учасниця мала
My
запитання, то ми
request
запрошуємо вас поставити його
is there is
після того, як всі підуть на перерву. Ми
another question. Please ask it when
просто
leave for the
порушуємо
break.
конституційне
We are
право на
violating
перерву, і більше
constitutional
не
right for
вистачатиме
coffee
часу.
break, and we should to
Ну, якщо
maintain
спікер
get the
наполягає, то
quality
я
if
я
speaker
прошу тоді
insists.
одне питання поставити, але
One
нас має
question,
просто
but
ці була рука.
briefly.
У вас, так.
Я відчуваю, у мене буде складне завдання.
I'm already
Добрий
feeling
день.
that will be complex task.
Суддя Київського апеляційного суду
I'm judge of Key
Євграфова.
Appeal Court
Продовжуючи
Євграфова.
велику тему щодо якості
In
судового рішення, яке
follow-up
буде перебувати на
of the
виконанні
topic
суду. Яким
quality
чином
of
суди
co-decision
національні мають
that will be
здійснити
enforced.
повідомлення,
In what
на
way
якому
Ukrainian
етапі цей
court should
обов'язок
make
процесуальним судом
notification,
буде вважатися
at
виконаним
what
належним чином.
stage court will
Ми маємо
believe that
розмістити
it
на
has
сайті
fulfilled this.
оголошення, адресоване
We
таке
must
агресору.
put it on
Ми
the
маємо
website,
зобов'язати
notification to
сторону
aggressor
через
country.
електронний суд
We
кудись
must
щось
oblige
надіслати.
the
Бо практика
applicant
у
to
судах
send
України
something
зовсім різна.
electronically
Є
because
випадки, коли сторони
practice
самі
is different.
особисто
There are
представлялися.
cases when the
Якщо не
parties
помиляюсь, це був
themselves do it.
Господарський суд
I
Запорізької області.
saw
Сторона сама взялася
decision of Zaporizhia Commercial Court. The party itself
кур'єрської служби дієчелу
decided to use DHL courier force to send all notification to embassies of European countries, and they themselves brought court resolutions to 7 European embassies involved in this case. And the court made it possible to make notification. In a regular district court, what the judge should do to fulfill the procedural duty?
Всі залежні від вас можливі дії. Все, що ви
You can
можете
make all
вчинити,
possible
Верховний
actions,
суд може
whatever you can
створювати
do.
на своєму
District
сайті
court
відповідний
can
розділ, в якому
create a
розташовувати
chapter
всі
on its
матеріали,
website
які
and put
є.
all materials there
Тобто для того, щоб принаймні спробувати
in order
виконати
that
такі
at
дії.
least to
Але,
try to
дозвольте,
fulfill
я
such
повторюю,
action.
ваше
But I
запитання,
repeat
на жаль,
again,
немає, і
there
не
is
буде
no answer to your question,
відповідати
and
на
we
це
shall not
на
have
потрібне
this
запитання.
answer before Verkhovna Rada
Ми
provides the
лише
answer to
з
such
точки зору,
questions.
так би мовити,
We can
лише
discuss it
легеференду,
only
з точки зору
from the
бажаного
point de
права.
lege vere, desired right.
Перше, український суд
Firstly,
не може
Ukrainian court
спілкуватися з
cannot communicate
країною, з якою
aggressor
припинені
country.
дипломатичні стосунки.
The diplomatic
Це
relations are
тим
terminated.
самим ви порушуєте рішення
Otherwise,
іншого повноважного органу, який
you will violate decision of other authority. We don't have official diplomatic relations between Ukrainian state and Ukraine court acts on behalf of the Ukrainian state and the foreign country. From the point of view of desired right, such communication should be through some independent third party, internet resource. But from the point of view the lege ferenda, you must provide some information that the other party knows about legal claims and the evidence provided and about all court decisions on that, and the main thing about court hearings appointed. Well, the latter is my personal consideration from the point of view the lege ferenda. From the point of the lege lata, You can put it on your website.
Колеги,
What
в мене є одна
session
добра новина, але
what
перед
did.
тим
I
подякуємо
have one
спікеру
good
за
news, but
взяття
before
участі.
that, we should thank the speaker.
Використовуючи сплячі повноваження модератора
using
дискусії, ми
dormant
перерву
powers
до
of
12:10
moderator,
трішки змінимо наш регламент, але
we
пані Вероніка
have
прохання
break
на нас 10.
until
Різні тут. Зверніть, будь
12:10.
ласка, увагу, що це
But
найбільша
at
перерва, якщо
12:10,
тільки можливо. Це
please
доволі
come back.
неприпустимо
It is
перебивати,
the
вкладайтесь
longest
в час.
coffee break. It was not easy to negotiate it. We look forward to get you here at 12:10.
На першому
Шановні колеги, я дякую вам. Майже дякую за майже пунктуальність.
Dear colleagues, thank you very much for coming back on time. And we will have the largest panel over these 2 days. And I believe that it's a good sign. We have a variety of expertise here, and we will be speaking about the compensation for damage caused by war aggression against Ukraine. I will introduce the speakers, and you can keep asking questions and think of what to ask. Now, there is Justice Vitaly Chernenky, Justice Serhiy Pogrebny. He spoke about the international register of damage, and this is an issue that entails a number of other questions from legal professionals and judges of local courts. And whenever it comes to the term register of damage, there is always a link to the name of Ganna Hristova. And Ganna Hristova will be one of the panelists today. Thank you very much for coming. During the presentation of the keynote speech, and while we had a very brief Q&A session, we raised issues about the execution of decisions by the Russian Federation or in respect of Russian Federation. And these issues will be very acute in the future, so the competent opinion of Serhiy Grishko, Chair of Procedural Law Committee, Ukrainian Bar Association, will be of relevance. Thank you for being with us. We will also have international consultant of the Council of Europe projects, Lilian Apostle, with us. And the attentive participants of this forum saw the title of this project, which is called Strengthening Judicial and Non-Judicial Remedies for the Human Rights Protection of the War-Affected People of Ukraine. And you know that it will be part of the international support, including support from the Council of Europe. And I hope that Lilian Apostle will be able to join us online fairly soon. I would also introduce Volodymyr Yavorsky. He represents an NGO called Center for Civil Liberties. In 2023, the scope of legal aid provided by the civil society organizations to war-affected people in Ukraine was huge. We don't have the exact numbers, but in terms of the scope of work, it was tantamount to that provided by the pro bono legal aid centers. And without the support of the civil society organizations, the entire system of pro bono legal aid would have collapsed. And it is a testimony that civil society organizations in Ukraine, with support of international partners, play a most significant role in this domain. So Volodymyr Yavorsky, welcome. And I'm Vitaly Chernenky, and we've already met. So while the panelists speak, they will have about 15 minutes of each, and then we will have an open discussion. Anna, you said that I overestimate speaking about the role of the register of damages. There are a lot of questions that people ask about this register. Can you tell us what we can expect of its operations? And legal professionals also ask questions about how the evidence can be documented, how the information can be entered into the register, etc. Thank you. Thank you for the introduction and for the opportunity to participate in this panel. I would like to thank the organizers, my esteemed colleagues, the Council of Europe's office in Ukraine, the Council of Europe in general, OSCE, Lviv University, and the Supreme Court for this opportunity to join in this discussion of the register. When it comes to the synonyms or case words for the register, it's about the Marianne Krzyzewski. And of course, you will know that together with the international community, it is extremely important that during the active phase of aggression against our state, the creation of the international compensation mechanism aiming to achieve justice and establishing mechanisms to the reinstatement of justice for people who suffered from the aggression is a unique phenomenon, both political and legal one. We are witnesses of this phenomena in making, but we wish we would never have had a need. So the best greetings from Markian, and it is important for us to have this professional discussion with representatives of the judiciary. I hope that over the time my presentation would be shown on the screen, and I hope we have it. Good. I also hope that the clicker could work. While we are waiting for the screen to show my presentation, I want to voice and then some of the policy documents and legal documents that create the framework for the register. There are lots of questions, you are right, about the register. We've got answers to some of them, and some of them are still unanswered. So the register is being formed and filled as we speak. So we should appreciate this difference between what we can comment on and what has been documented already and what we can just foresee as a step in the future. Yeah, I see the screen, but the clicker doesn't seem to work. Or you can ask our colleagues to change slides. Could you show us the next slide? This slide with legal and political grounds for the creation of the register of damages caused by the aggression of the Russian Federation against Ukraine. The first such document was the UN General Assembly resolution, which was then translated into Ukrainian, and it is a resolution of the 14th of November 2022. It is essential that it is the resolution of the General Assembly, and it was supported by 94 UN member states. And these are the highest expectations that we can have And we believe that it adds to the development of the international convention mechanisms if all of these member states contribute to the forming of the register and of the compensation fund. It is this resolution that documented for the first time the need to set up the register of damages caused by the aggression. So as you can see, it is November of 2023. The next milestone is May of 2023. In response to the call by the UN member state signatories of this resolution, and thanks to the very proactive effort of the Ukrainian government, the Council of Europe decided to provide a platform for the establishment of this register. So in May 2023, the Committee of Ministers of the Council of Europe approved the statute of the register of damage caused by the aggression of the Russian Federation against Ukraine, and accordingly, this instrument established by an international institution through the extended agreement, the partial agreement. The extended means that it is still open to support and to accession, not only by the participating members of the Council of Europe, but other countries as well. Amongst the participants of this register, there are the USA, Canada, and Japan. These are the countries that are not members of the Council of Europe. And in this country, in this context, we would mention yet again the 94 UN member states and our standing call for them to join in this register. And there's also the community of such countries, and there's a consolidated will of the EU member states and the members, the EU as an organization is also participant on this register. The next milestone refers to September 2023, where at the conference, non-formal conference of ministers of justice of the Council of Europe participating states, the major principle was formulated that the register is guided in its activities from the maximum protection of the victim's interests. That's a victim-centered approach, as it is known, and this approach is guiding the register in its day-to-day activities, in the development of the various categories of claims that will soon be open to the potential register users, and the principles guiding its operation. And I will give the examples at a later stage. And I will also comment on the fourth key milestone. It is the 2nd of April 2024, when the register opened the first category of claims for submission by the affected individuals. This category is called A3.1. It is about damage or destruction of residential housing. So Ukrainian citizens or residents of Ukraine can file their claims in this category of cases, and those who live in temporarily occupied territories are also entitled to file their claims. Now we received the first 10,000 claims. First and foremost, from the city of Mariupol, we received 1,500 actually claims from there. They also quoted an amount, which does not mean, however, that it is exactly the amount that can be or will be paid as a compensation. It's just the claim. It is 24.7 billion hryvnias, the overall amount, which, as I said before, does not mean in any case that it is the amount to be paid as compensations, because it is not up to the register to decide on the amount. And I will comment on that a bit later. Can we have another slide? The next one, please. So, as I said, only one category of claims has been opened so far, and the statute of the registry defines the mandate of the registry, of the register. Likewise, okay, we've got the presentation, that's good. And the statute and the rules vis-a-vis the handling of claims, we would be discussing the key criteria of admissibility of claims. So the register serves to document damage or loss caused in the territory of Ukraine within the internationally recognized borders, which is important, in the territory of Ukraine within its internationally recognized borders, including the temporarily occupied territory. Since the 24th of February 2022. And this damage or loss should be caused as the caused by the illegal actions of the Russian Federation against Ukraine. So manifestly ill-founded actions, which means that the evidence that can be provided by the claimant should be provided. But the general principle, and we remember that victim-oriented approach, right? The mass complaint mechanism will be applied towards the assessment of damage caused by the war, and the register would be proceeding from the criteria of minimum standard of proof. Right, the claim or the complaint cannot contain no evidence at all, but this will be evidence that can be provided and can be assessed, because the assessment of damage in the temporarily occupied territory is a challenge. I've got 3 minutes, and I will use this time to speak about the criteria of admissibility. You understand that. Then summing up the register is the first step in the establishment of the international compensational mechanism, the ad hoc mechanism established for the sake of the victims of this aggression and enabling them to get the compensation. There would be other judicial, quasi-judicial mechanisms. There are lots of questions and subject matter for the discussion, but it is a special targeted ad hoc mechanism set up for the very specific task of restoring justice and compensations to the victims. Then there would be compensation commission. Now it is in the making, and we hope that the international tool will become operational by the end of 2025, and the commission will be formed in 2026. And we are speaking about the international level going beyond the geographical boundaries of Europe. And there is a lot of publications about it. There are various opinions and discussions, though this topic goes beyond the mandate of the register, and I'm not in the position to discuss it right now. Another important matter is that the register already approved the list of the categories of claims, 45 to be exact. Can we have the next slide, please? referring to individuals, that's physical persons, local authorities, and businesses in category C. And the next slide, please. That's about the victim-oriented approach. Next slide still about the categories of claims. And the next one yet. Okay, there is a lot of information. There is a lot of reach out that the registry is doing. All of them, all of the categories, the list of the categories is available on the website of the register. You can Google RD for you or Register of Damages for Ukraine. All of the documents are available in English and French as the official languages of the Council of Europe, but also with translation into Ukrainian. And you can see the list of categories of claims. There are just 12 there. Some of them combine several ones because I mentioned 45 at the beginning. Since it is a forum for the judiciary, we should be speaking about the court decisions on compensations that can be entered into the register. The national level and the national system is what the registry knows of, and the register pays special attention to whatever happens at the national level in terms of understanding what evidence should be collected from the claimants.
The applicant can file an application in the framework and 45 categories. The format of complaints approved and those that are under discussion provide that court decisions could be such that are enclosed to the relevant application. And last but not least, quotation from Article 21 Part 3. Rules of submitting application. When making decision, the board of the register can take into account decisions taken by international courts or tribunals or other jurisdictional bodies that take in mandate of the register that are taken into account, but register is not bound by them. It is a traditional approach of international institution, which is acting independent, not depending on national tradition, take into account national interest and decision, but not bound by them. That's it. A lot of information, but no time. Thank you, Hannah. I think that you can devote entire panel to register. Now I give the floor to Volodymyr Yavorsky. Hannah mentioned court decisions. Today we have discussed individual court decisions made by Supreme Court. What is your viewpoint on case law as human rights defender? Which elements are important for you for compensation for ruined or damaged property? I represent Center of Civil Liberties. We conducted studies, analyzed some 300 decisions in civil and commercial cases regarding compensation of damage caused by Russian Federation. Claims of physical and legal entities to Russian Federation reviewed by Ukrainian courts. We reviewed decisions as of May this year. Now this number doubled by September. In September, we found 600 of such judgments. and their number is quickly growing. This mechanism is becoming more popular. I will start from what Mr. Pogrebny said, making several focuses. Later, I will tell you about our detailed study, which is quite huge, and it contains more information that I will give to you now. First question, need of society. At the beginning of 2022, there was no mechanism how theoretically a person could get any compensation from Russian Federation. But later, this mechanism was established by Supreme Court, and it was confirmed several times by decisions of other courts. We have already quite consistent judicial practice. It's difficult for me to understand how it can change by itself, but still I see some debatable issue. Mr. Pogrebny paid attention to issue of immunity. I think it's of secondary importance. Immunities, it's a very debatable issue. Can Ukraine ignore immunity of Russian Federation? It is debatable in international law. There are many disputes. The second repeated case in UN court, numerous disputes between Italy and Germany. There is practice in other countries, but in the context of immunity, Ukraine has a very strong argument. For some reason, it was not used by Supreme Court. Immunity of Ukraine in Russian courts was violated since 2014 in many courts several times. Temporary occupied territories. We lost a lot of property nationalized or removed from Ukraine. This is violation of Ukrainian immunity in Russian jurisdiction that involves use of reversive principle that we have the right to limit their immunity. But we must look at the immunities in a broader sense, and it's not a key problem. The key problem is the case law of European Court of Human Rights and human rights that are problematic issue. The basic thesis of Pogrebny, there was a need of people. Society needed this mechanism. And second, we didn't have any real mechanism. Then I ask opposite question, whether this mechanism is real, as European Court said, it should be effective. Protection mechanism must be accessible and effective. Effective and efficient. It must restore violated rights. If these rights are not restored, mechanism is not effective. It doesn't achieve result intended for. This context, there are several nuances. More judges recognize that there is no mechanism for execution of this judgment. Ukraine adopted a law on confiscation of Russian property. There is a law that has confiscated all Russian property, which is transferred to state budget, but not a single word about possible compensation issued by national courts in these cases. There are more issues in this mechanism caused by the fact that one of the grounds for making decision by Supreme Court that every person has a right to address the court. And if the court rejects these complaints, this is violation of right of fair trial. But state of Ukraine doesn't have commitments to guarantee rights violated by other countries. Human rights, these are relations between an individual and the state can safeguard mechanism of protection regarding rights that it itself guarantees. This legal relation between the state and Russian Federation, it originates other legal consequences. In this case, European Convention cannot demand from Ukraine to create mechanisms protecting from other states. If you go further, right to fair trial doesn't end with application to court. It ends with the execution of judgment. Even at the beginning of creation of this mechanism, we don't see even theoretical, illusory execution of this decision. We can hardly speak that there is an available mechanism as an effective mechanism of legal protection. Other problem is caused by the fact that there are numerous legal problems when making decisions. We have analyzed some 300 decisions, and they all have problems as regards right to fair trial in the context of proper notification of respondent regarding the case. In many cases, there is no notification. That means since there is armed aggression and no diplomatic relation, there is no obligation to notify. This practice is not regulated at all, and it is used differently in different courts. There is no representative, there is no equality of parties, no documents in the language of respondent. Decision in the case is not sent to respondent. If we perceive it as a quasi-judicial consideration in absentia, this is in fact consideration of case in absentia. According to standards of European Court of Human Rights, it should be a mechanism of revision of such case when respondent appears, but these cases don't have it. And the right to fair trial is key for execution of these decisions in jurisdictions of other countries, not only public mechanism, but due process, right to fair trial, and very many questions will arise. I want to emphasize a number of other problems that arise.
The issues of the court fee, which is difficult to define, and practices vary here. Then the issue of the absence of notification and the absence of revision guarantees. And there's another important issue, and that's the criteria for establishing the amount of the damage caused. If we analyze the previous court decisions, there are no criteria whatsoever, and the compensations are awarded in the amount claimed. And in fact, we don't have any objective criteria. We have the difference or delta of to the effect of 10 times, right? And it can be a problem with the use of these decisions, even within the view of the register, if the difference in the amount is so big. So the question arises whether this amount can at all be compensated. And the criteria are important for the prospects of development of this mechanism. According to the criteria formulated by the judicial system, each citizen of Ukraine can seek redress and compensation from court in case they suffered damage. If, say, a shahed flies over the roof of the house where a person lives, they can get a compensation to the amount of moral damage awarded up to 400,000 hryvnias. But today, we suffer those attacks every day, and every Kievan who lives in Kiev now can claim 400,000 hryvnias of compensation every night. Can you imagine that? So I'm worried for our judicial system. If each citizen of Ukraine starts filing such claims, even formalistically, it will overwhelm the judicial system and the system will collapse. Another issue is about the enforcement cases. As far as I know, only 6 such enforcement cases were opened, but no writs were executed. And I understand that all people whose decisions were not enforced will be in the position to complain to the ECHR, saying that there is no mechanism of enforcing such court decisions, and Ukraine will be held liable for failure to introduce the mechanisms for the execution of such court decisions. And I am sure that Ukraine will have difficulty responding to such allegations because the mechanism is so formulated that it does not provide for the execution or enforcement. Moreover, there are certain evaluation opinions of Georgian legislation by the Venice Commission, whereby the state, when it establishes jurisdiction over certain legal relations, then should be accountable for the implications or consequences of the use or application of those mechanisms. And if thousands or hundreds of thousands of people go to the ECHR, can you imagine the situation? And I know that in Ukraine there is the so-called legal business of claimants who, for the fee of 1,000, 2,000 hryvnias, would write the claim statement. Some of them were banned by the European Court of Human Rights, and some lawyers were disciplined for that. But I saw in law forms certain advertisements stating that they are prepared to file such applications to the European Court of Human Rights, and they claim that they can guarantee that those cases will be, or those applications will be admissible. I've never heard of any success with such applications, but there is a problem, and unless something is changed, we will have thousands and thousands of such applications in a year or two from now. People will be paying 1,000 hryvnias, that's no problem, aspiring to get millions or hundreds of thousands that the Malafide lawyers promise to them. Thank you very much. You mentioned the enforcement of court decisions several times, Volodymyr, in your intervention. We understand that enforcement of court decision is part and parcel of any legal system. Without it, the judicial system means nothing. So with this, I will give the floor to Serhiy Hryshko. And I expect that he will comment on the enforcement of court decisions and also the so-called legal business referred to by Volodymyr before. Thank you very much, dear colleagues, friends. I'm very glad to see you all. Thanks to organizers for inviting me. Thank you to the Supreme Court, the Council of Europe, the OSCE, and for the Armed Forces of Ukraine for defending us. Can I have my presentation shown on the screen? I prepared my presentation in English, so My slides will be in English. I hope that you will be able to read those slides. People who are present here know English, I'm sure.
Одразу перейти до головного. Ну, на мій погляд, так?
So down to business then. The key things for defining the system of coordinates within which we operate. And it looks like this. The war, the aggressive war, is an inadmissible act of aggression. It has been banned since 1945 by the UN Charter. And if an international law prohibits something, so it is the toughest, the strictest, the most stringent prohibition. And we can see that in the UN Charter. Unlike the period of the classic international law, this one is a total prohibition. Then we are at a European forum, so there is the ICJ forum, judgment of the 16th of March 2022 that prohibited Russia to wage this war. There is a formal legal prohibition. There is also court order, court prohibition. It never stopped the Russian Federation, though. And then after the crime, there is punishment, and that's what the legal tradition teaches us. And since it is a violation of the international humanitarian law, waging of an aggressive war, then the punishment should take the form of full reparations or compensation of damage. So the liability is okay, but the liability has not taken place so far. So what do the poor Ukrainians who suffered from the war do? And here I have to thank Mr. Pogrebny for his most interesting presentation. And I should add that not only at the beginning of 2022, but also at the end of 2024, we have no effective mechanisms at the national level for the Ukrainian citizens and legal entities to get any reasonable compensation. What the Supreme Court did was something that it had to do, because that's the function of and calling of the court to defend the rights. If there's no one else to do it, then it is the court. Because it is its key constitutional role. And according to Irina Mudra, Deputy Chief of Staff of the Presidential Office, there were 397 decisions on compensations for damages caused by the Russian military aggression in the register. Now, what's going on right now? According to the Supreme Court, and Mr. Pogrebny has commented on that, the violation of use cogens of the norms of the international law deprives the aggressor state of the right to refer to the all rights and to the Convention of the Human Rights. So there should be no misinterpretations here. And the decisions of the trial courts are very explicit in it. The Ivano-Frankivsky court actually surprised me with their clarity of thought. Do we have anyone from the Court of Appeal of Ivano-Frankivsk region? It's a pity. I at my accord. The acts of armed aggression by the foreign state are not an exercise of its sovereign rights, but a violation of the obligation to respect the sovereignty and territorial integrity of another state, Ukraine, as enshrined in the UN Charter.
Що ж нам каже, звісно, тут велике заперечення. Що каже міжнародне право?
So what does the international law say about it? There's a quandary here, I would say. The immunity right is the customary law. There are two conventions that regulate these issues. The European Convention on Sovereignty, and there is also UN Convention on jurisdictional immunities of states and their properties. None of them, or neither of them, has taken effect for Ukraine. According to these conventions, we know when the country can refer the jurisdictional immunities. According to the overall rule, it has this immunity, but there are some exceptions and exclusions. And if we look at how it works in practice, the earlier mentioned ICJ case of Germany versus Italy and the Greece intervention of 2012. And many of us were looking forward to it, and it should have actually crossed all T's and dotted all I's. It did so at the moment when it was taken. May I remind you about this case? It was about the responsibility or financial liability of Germany for Holocaust in the times of World War II in the territory of Italy and Greece. And ICJ said that with regard to these facts of Holocaust and crimes committed during World War II, Germany has a complete sovereign immunity. But this judgment was not unanimous, and you can see that there are minority opinions, as is the case. At first, it appears as a separate opinion or minority opinion, and then it becomes mainstream. And there was a dissenting opinion of Judge Comunicado Trinidad, who said that serious violations of or grave violations of human rights and international humanitarian rights that amount to the international crimes are anti-legal cases, are the violations of use cogens that cannot be removed or omitted by reference to the sovereign or jurisdictional immunities. And they are not actiorgis bentionis, that's acts of the public authorities, nor are they acts of private law.
They are crimes, public crimes, crimes of public authority, for which there could not be immunity. His opinion was repeated by Judge Yusuf, who says that immunity is not unchangeable value in international law. Its adjustment to evolution of international community, its flexibility is confirmed by a number of exemptions that were accumulated during last century. Most of them reflect the growing normative value that is provided to protection of human rights against the state. In exceptional circumstances, immunity can prevent victims of international aggression from international compensation. Judge Kaya also said, allow me to quote, in principle, It's not clear what there is tort exception for delict. The state is deprived of immunity. If you damage it at work and you must pay it, compensation, but if the state kills you, you will not get compensation. From the point of view of ideology, it's not clear. Here we see origination of certain international habit. Most of assets that money for compensation could be taken are outside territory of Ukraine. In Ukraine, we don't have a lot. As correctly Mikhail Vodyanikov said during previous debate, potential users of Ukrainian court decision will not be Ukrainian state authority. There is a question that with proper notification, there are complications here. We cannot send anything to Russia. Diplomatic relations are severed, but courts find creative way out of this situation. And there is judgment of Zaporizhia Commercial Court upon application of Slavutich Invest to Gazprom about charging compensation for expropriation of certain assets in Kherson region. And the Commercial Court, Zaporizhia region, used alter ego doctrine and recognized that Gazprom is an instrument, a body of Russian state, and charged compensation. That was a daring decision. It was not appealed. And later, party, Slavutich Invest, applied to the Dutch court asking to execute this judgment. Up to now, there is a judgment for the Hague District Court on arresting assets of Gazprom. The substance of the case was not discussed. Gazprom asserted that Gazprom is not a part of the state. The Russian state has sovereign immunity, therefore responsibility cannot be imposed on Gazprom. And the Hague District Court ruled that in principle, now the fact that compensation is ruled to Slavutich Spes is not the consequence of aggression, but rather consequence of expropriation of certain property. There is not a clear prohibition regarding immunity. But anyway, up to now, this is a preliminary decision of the Hague Court, arrest of asset, and then the further decision will follow. I will not speak much on that. My time is finishing. What all that means? It proves origination of the new international habit. Sovereign immunity is an institute of international conventional law. What we see now is a case which, in my modest opinion, becomes a pioneer, a leader in forming new international habit, violation of imperative norms of international order by means of aggression is not acceptable, and it does deprive the state of the right to refer to the immunity. Recognition of this international habit will take time, but I think we are moving in the right direction. Next, a few words about register and interaction between register and Ukrainian court judgment. In my view,
важко щось додати до
it's
блискучої
difficult
презентації
to
пані Ганни
add
Крistован.
anything to the wonderful
Я би хотів
presentation made
додати
by
лише
Hanna Kristovan.
кілька речей.
I would like to add only a
На мій
few
погляд, українські
small
судові
things.
рішення
In
і
my view,
реєстр
Ukrainian
не
court
є
decisions
сильно
and the
виключаючими
register
одне
are
одного.
not
Це
mutually
абсолютно
excluding.
комплементарні речі.
These are
На мій погляд,
absolutely complementary
український суд
things,
навіть
in
виконує
my opinion.
терапевтичну функцію.
Ukrainian court is
Звертаючись до
fulfilling some
суддів,
kind of
якщо
therapeutic function.
як на прийомі
When
до психолога, ти розказуєш свою
addressing
історію,
the
тобі стає
court,
легше.
like
Йдеш
with
до суду,
psychiatrists, you're
судове
telling
рішення
your
виносить,
story,
трішечки ти отримаєш хоча
court
б
is listening to you,
самосатисфакцію,
they're
що
making a
хтось тебе
decision,
почув,
and you
вислухав.
get moral
Але
satisfaction.
головне те,
Somebody
що
heard you.
час минає,
But
війна
time is
триває.
passing,
Свідки
war
злочинів,
continues,
завдання шкоди
witnesses of crimes, of
забувають.
damage are dying, are forgetting,
Самі ці сліди цих злочинів затираються.
traces of crimes are disappearing. Look at Bucha and Irpin. They have been ruined, but now they look such way that you can finally see the traces. What is important is court decisions. And what is seriously important? The question, what to do with the amounts of compensation? In here, seems to me answer should be quite simple. Register has its right to distribute the compensation based on the rules elaborated by the register. There are multiple creditors against one
Тому так чи інакше рішенням
bankrupt.
українських судів, на мою скромну думку, має
Decisions of Ukrainian court must be provided judiciary effect, recognition of the fact of damage incurred, but definition of amount of compensation, discretion should be used to ensure maximum fairness, equality for all. Thank you very much, Sergei. We have two remarks in the course of discussion. Initially, I give the floor to Sergei, since his keynote presentation was mentioned many times. Participants are asking very difficult questions, so I shall use debate between us to answer this question. It's a joke. The phrase that you quote from Ivano-Frankivsk appeal court, judges of appeal courts are very qualified, but there's a decision of cassation court, which they used. This is the first reservation. Well, sorry for referring it to Ivano-Frankivsk court, a decision of the Kiev court, which became very close to me. Second remark, this decision from April 2024 of the Cassation Civil Court, in fact, was the most important at that time. They changed the practice that existed before. Before that, Cassation Civil Court have used the law on international private law, saying that Ukrainian court can review cases regarding foreign country only pertaining the country that provided consent to it. What courts were doing? They sent a request to embassy. Embassy either didn't reply or didn't accept this correspondence after not receiving the consent. The court was just closing the proceedings. Based on the provision of the law, it was not possible to review such cases against aggressor country in the Ukrainian court. In April, the Cassation Court opened the way to do it. Before that, there was a legal provision. It's impossible to do it. There was not a single case. Cassation Civil Court in April 22 reviewed the case about termination of the proceedings. But the Cassation Court said, no, And that changed the practice. Without this decision, other cases would not follow. Second, look at the rationale, the logic that pertains now. Cassation Civil Court clearly formulated criteria and possibility of use of this delict exemption. They either don't see them or write that it's written application of norms and rules in disputable cases. Cassation Civil Court clearly defined that it pertains to claims of physical person. Then, second, damage incurred to that person or his descendants applied to the court on the sovereign territory of Ukraine. At the stage of opening the proceedings, one should have done the conclusion, alleged conclusion, that this damage was made by agent of aggressor country. These criteria should have been analyzed by first instance court at the stage of opening the procedure. And in case these criteria are established, criteria of delict exemption, first instance court must open the proceeding. Therefore, the quality of justice in this category of disputes must be extremely high. The extremely complicated issue. You cannot make decision about opening procedure half a page long. 5 criteria of delict exemption must be included into this decision on opening procedure. Hannah, your comment, please.
Дякую. Так, ні, все прекрасно працює.
Thank you. Microphone is working. It will not be an obstacle, neither for discussion nor for submission of application, because submitting application to our register through DIA system is difficult technically. But my comment is based on the final statement of esteemed Justice Pogrebny, the quality of national judiciary. First, esteemed Sergei mentioned, actually finalized with the register and national court decision. Yes, you said national court decisions, this is kind of panacea, kind of moral support, possibility to express yourself, but you should not bring this message to all victims, both physical persons, business, communities, and state as a whole. You should not bring the message that register provides the possibility to apply to the register irrespective of the decision of the court. All applicants, including legal entities, must understand that they pay considerable money for this.
Це та теза, яка на сьогодні рухає саме нами, рухає міжнародною спільнотою.
This is the premise from which we, together with the international community, are moving when people are working on filing their claims, and we in the register collect those claims, we accumulate them, the claimants give evidence with the appraisal of their loss or damaged property, but we don't know the decision of the commission because there is no commission in place so far. And the register is to be established here and now, and it should be filled in because the traces are disappearing fairly fast. So the availability of these traces and the evidence that is still available to the claimants like the testimony of the neighbors or the testimony of the witnesses themselves should be enough to make the claim, to file the claim. And they should be aware that they do not have to go through the judicial procedure. And there is another point here that the evidence and the documents can be added at a later stage, which means that if the claim has been filed, but it hasn't yet been considered by the board, and then the court decision is taken in the meantime, then you can complete your file with that decision. And now when it comes to the appraisal, of course, I cannot but agree with it. The register would not be doing the appraisal, but the compensation commission will develop the necessary rules of appraisal and the criteria of including the balance, justice and fairness, etc. And the register would not be proceeding from the exhaustive list of evidence that can be claimed. With the appraisal of the damage caused, it can be done by the court experts or by private appraisers. The register will be speaking about the general principles that can be of use to the judiciary. In no way is it going to be the interference into the national judicial system. We would not be saying that this appraisal is acceptable and that one isn't. But the principles should exist and they should be of value to both national institutions and international ones. Some court decisions impress you or stun you, should I say, with the awarded amount of compensation. So it's again speaking about the very thorough assessment and study of the evidence. Thank you. Thank you very much. Sorry, Volodymyr, at a later stage during the general discussion. Is Lilian with us? Are we ready to hear from him?
Yes, if you hear me. Well,
Так, є зображення, а чи є звук?
I need a confirmation if you hear me.
We can see you but not hear you. Just a moment.
Okay, it's nothing on my side, but I think I will keep speaking until, well, yesterday there were technical issues on sound. Okay. On my side, everything is okay. It is.
We can hear you. Everything
Okay, good, good. Thanks. I have a presentation as well. Host should give me the rights to share it. But, well, and I will keep talking. And first, I would like to welcome my oldest colleague, I think, Jana. Jana, where are you? I see you because you worked, I think, last year we talked about in the same forum about compensations, and we did a quite substantial study on that. I will get back on that. I will jump straight to the point because this is my disadvantage of being the last of speakers. And I heard a lot of arguments in favor or against state immunity. Okay, thanks. I have presentation in translated in Ukrainian. Okay, sorry for keeping you. Do you see the presentation first? It is in Ukrainian or?
No, not now. Maybe you can share with us from your side on Zoom.
Yeah, this is what I'm trying to do. Sorry for this technical, but I think we need to have something on the screen. Okay, this is what I would like to share. Okay, sorry. Okay, now you see?
Yes.
Okay, sorry for this. So as I told, this is my disadvantage of being the last speaker, but also an advantage because I saw many arguments and they actually fit my analysis of the problem on state immunity. But I see the problem of state immunity and the most importantly of the practice on lifting the state immunity, not in this narrow vision as it was at least presented. So it depends on the perspective how you look on this development of Ukrainian judicial practice on lifting immunities. And I'm referred only on lifting immunities of the Russian Federation, of the state immunity. This is the only topic that we will going to discuss because there are other problems on the compensations following the armed conflict that is Ukraine is involved in. But we will focus only on the state immunities and the other problems that actually arise from this. From my point of view, as a general comment, I don't see the problem of state immunity so difficult in order to not be able to be resolved. It is not that problem that is actually you should be concerned with. There are other more significant problems that actually raises more serious questions, and I will get back on these problems at the end of my presentations. So reiterating, Ukrainian courts began to deal with the compensation following the armed conflict. And I'm deliberately using armed conflict as not the war of aggression because there is a big difference because it's from international humanitarian law perspective. It is important. And most importantly, there are customary rules. There was already mentioned 115 rule, customary rule that state should be responsible and should pay compensations, reparations actually, for the breaches of international humanitarian law. International humanitarian law begins to apply when the armed conflict begins. So when this conflict, international armed conflict, began in 2014, with with annexation of Ukraine, and well, the history we know after that. So what happened in this year? It is actually that from legal point of view, it is the war of aggression. So that actually changed the approach of Ukrainian courts and basically the Supreme Court. We speak of the Supreme Court. At that time, after that, they found that it would be a proportional measure to lift the state immunity. Okay, next we have a development of the jurisprudence basically on these grounds. And there I see some issues. Not the problem of immunity. Because of immunity, we can speak, and I will bring some arguments in favor, and as well as against, we will speak about this. But I see here, for example, the problem. I see the problem of how to evaluate these moral damages and so on. So back to the problem of what kind of general problems this change of practice actually raised? I see 4 types of problems. This is, of course, the main topic of our today discussion. But other 3 topics, they will never have been discussed, at least publicly. But some arguments on that were brought in the context of discussion on the legitimacy of lifting the state immunity. I mean, for example, the problems of in absentia proceedings, although in absentia proceedings technically do not apply to civil proceedings, and to this particular, I will speak about this, I will mention this later. These are more or less ex parte proceedings, they are not in absentia. In absentia, the problem is in more or less in criminal proceedings. In civil proceedings, we have a different approach. Okay, what are the arguments in favor or against? Basically, these are the arguments brought by the Supreme Court. This is the seriousness of and gravity of aggression, actually justifying the lifting of the immunity, territorial tort exceptions, and the access to the court. Within the meaning of basically of Article 6 of the European Convention. Against this jurisprudence of lifting immunities, there is basically three basic arguments. This is the argument that lifting immunity breach the International Court of Justice dicta in the famous case Germany versus Italy, that the real problem of enforcement of these judgments, basically these are judgments are declaratory. I mean, the European court judgments, not European, Ukrainian court judgments are basically declaratory. And there is a problem of unfairness of the civil proceedings, basically referred to in absentia. Okay, my analysis of the problem of lifting immunities is actually twofold, basing on these arguments. First, I would like to change the perspective of seeing the problem of lifting immunities. First, lifting immunities, we should take it as a fait accompli. No, regardless of excruciating arguments that we can brought, it is already there. The Supreme Court changed this practice. So if we would look on this practice from this perspective, we will see what kind of valuable arguments the Supreme Court had and why this practice of lifting state immunity is actually should be kept. So basically here we will see that there is a problem of applying the so-called territorial tort exception to the act of aggression, which is not so-called acta iure gestionis. No matter how you try to extend it to consider that this is basically a civil relations between some, you cannot apply this to in relation to the war of aggression in general. You cannot apply this. This is the basic idea of that. But on the other hand, if you leave these territorial tort exceptions and all excruciating arguments related to it, you actually have two very, very valuable arguments that I've heard about them, and I think, in my opinion, they're quite justified. First, this is so-called ultima ratio argument. I mean that victims have no other means available to claim compensations from the Russian Federation. And this is valuable for that time when the Supreme Court issued the famous judgment and lifting state immunities, which actually brought the follow-up judicial practice of Ukrainian courts. So there are now available means for the victims of war. And this argument could be supported by international law, but the international law does not leave victims in limbo. You cannot interpret international law in the sense that is actually some questions do not apply. There is also the constitutional doctrine of so-called constitution is not suicidal pact. This means that it doesn't have vacuum in the protection of the rights of the victims, and in our case human rights, and the European Court has actually applied for this very strong argument to some cases that convention cannot create a vacuum in interpretation. You need to apply it in a positive way. So we can go and go and go in this argument. The point is that Supreme Court followed this idea, and I think it should be explored. And another argument that was not actually explored neither by the Supreme Court nor by the speakers, that state immunity, including especially in the International Court judgment on Germany versus Italy, has not dealt with an open armed conflict. State immunity there was in a so-called post-bellum situation, so the logic of keeping the community relations, international good relations between Germany and Italy was valuable. It is not the valuable argument in the particular and exceptional situation of Ukraine, when Ukraine is in an open armed conflict with the Russian Federation, and there are no other available means for the victims to claim compensations. There are no international adjudication mechanisms, and the registry, as Hannah said, it is still in development. There are no adjudication mechanisms. It's still registering all the claims. So what Ukraine found itself in the situation, there are no available means of remedies, and I think this argument could be explored more and more in order to prove, because there is a tendency actually to lift state immunities in this kind of situation and international law. And the next, I think, not less important argument, this is legal certainty. Well, as I told, we have this judgment, this jurisprudence. It already creates legal certainty, and the reversal of this. I mean, the turning back the jurisprudence of the Ukrainian courts in granting immunities should be made also on the grounds that it actually removed the motives on which it was based. Basically, the argument is that immunity would reappear when the war ends. So I think this argument also could be explored in the discussions. Next argument, which is, I think, not less important, and we spoke about, and I heard opinions on that, to which I basically subscribe, that actually lifting state immunity should be considered as a kind of an effective way of somehow remedying the situations. If we will look in this context, and if we will look on the civil jurisprudence of Ukrainian courts, it should not be taken out of the context of the armed conflict. There are other available means, there are other mechanisms of ensuring accountability of Russian Federation for the war of aggression, and this civil jurisprudence should be put in that context and should be used with other mechanisms. It should not be standing alone. So this is the point that you need somehow to see a mechanism of connecting the civil court judgments awarding these compensations with criminal proceedings, international criminal proceedings and national criminal proceedings, because there we don't have immunities, with international mechanisms, follow-up mechanisms, and in current international mechanisms, this is the registry, and you should keep this this jurisprudence in the perspective of other international proceedings. So where both state and individual criminal responsibility will be examined. So the main idea that war, an ongoing war, wipes out the state immunity as a benefit of common to have good interstate relations. There is no argument that you have a good international relations to keep this state immunity intact in the open war. So basically, from international public law perspectives, this somehow could be considered that Ukraine adopted as a countermeasure against Russian Federation and lifted its state immunity. So this argument is, I think, stands. And well, sorry for taking for so long time, but I would like to shift a bit of focus from state immunities. I think it is already resolved on other problems that this jurisprudence raises. And these, I think, the problems for the future considerations. First, what I saw from preliminary analysis of the Ukrainian courts jurisprudence awarding compensations are three main problems. First, almost all compensations are attributed on the so-called base argument jus ad bellum. Because of the illegality of the war of aggression, we are entitled to award compensations. It is difficult. It is difficult. This is not the argument you should be used in, at least from an international humanitarian law perspective, because international humanitarian law requires a clear distinguishment between jus in bello and jus ad bellum. So the compensations are justified for the breach of international humanitarian law, for the unlawful hostilities, for collateral damages, and so on. These are all arguments of jus in bello. I mean, there is a need to establish a clear connection between the concrete military operation attributed to Russian military forces and the collateral damage or direct damage caused to the victims. You cannot just simply say and close your eyes and say, because of the war of aggression has started in 2002, we are entitled to award compensation. This is not the argument that is actually should be used by the courts, and this is why I think most of the foreign courts, if they will meet with this kind of judgments, this was a court mentioned in The Hague, that is actually with questioning this argument. So there, I think you need to work out with the how you justify awarding compensation, how you attribute responsibility of the Russian Federation. But these attributions should not be based on the jus ad bellum argument. So next, of course, we have serious concerns about the ex parte proceedings and the problem of notification, but I think this problem could be resolved. Now we worked in the Council of Europe, by the way, in other projects of Ukraine, we worked on some mechanisms of using some creative mechanisms and ideas to ensure notification in criminal proceedings. And I think that in the situation of severe diplomatic relations, yes, there are ongoing on that. So I think we could use the same mechanism in civil proceedings, but my main point that the requirements of notification in civil proceedings are not so strong as in criminal proceedings. So we are in a best
Ліліана,
situation
я
here.
перепрошую, маю вас
One minute,
Дякую.
One minute, and this is, I will come to the end. I think the most difficult problem here with your jurisprudence in awarding compensation, this is the alleged breach of another principle of natural justice. I mean, you cannot be the judge in your own case. Ukraine is a victim of aggression, and this means that it actually ascertains the compensation for as being as a victim. It is the judging its own case. So this is the problem, I think, that we need to work out. For this reason, we have the only available legal solution to that. This is an international or mixed tribunals that actually would adjudicate objectively and independently the problem of compensations. But again, here I just illustrating the problems that we need to focus and we need to be creative in resolving these problems because they could be resolvable, and well, I'm just illustrating that. So you need to shift your attention from the problem of lifting state immunities, which is actually basically a procedural problem, and it could be resolved by some arguments that I brought already. But the problem is more fundamental. In here. And last and not least, I here recall our work with Ghana. That is a problem of amount of compensation that was actually given, and reparations and include not only compensations. There are other means of reparations in international law for the wrongful international act, and there is a serious step. Procedural steps how to award compensation. First, I already talked. This is attribution. This is establishment of the wrongfulness. This is causality, and then you need to ascertain whether this is a restitution possible, compensation, satisfactions, and so on. There is a whole theory on that. There are a lot of studies made for favoring development of Ukrainian judicial practice. You can just look back on them. But here we have also, again, the third problem that I see in this jurisprudence, because it is usually seen that, okay, because of the aggression, we are entitled to grant the full reparation to the victims without considering proportionality of this reparation and the effectiveness and the perspective of execution in the future. Thanks. I'm sorry for keeping you so long, but I think I raised some questions for the discussion, and if I raised them, so I fulfilled my task. Thanks.
Дякуємо, пане Ліліано. Я сподіваюся, ви чуєте оплески і дякуємо за те, що підсвітили нам важливі аспекти цього питання, власне, комплексний, не тільки
Thank you, Lilian. We hope that you can hear the applaud, and thanks for highlighting some of the problematic issues and the international law aspect of it. We are behind schedule, unfortunately. I don't think that if we have already violated it, we can not do that even more. So comments, questions, just one question for the sake of having a Q&A, unless you are too hungry to do so right now.
У нас там досить швидко вечеря, тому
Добре, тоді максимально коротко, чи є реєстр
Very
збитків
brief.
альтернативою чи
Is the
доповненням
register an
системи
alternative or a complementing
Що це
thing
питання
to
до
the
пані Ганни.
recovery system in
Питання
DIA?
пролунало так швидко, що його
So
треба
that
було
was such a quick question that I didn't get it. Your question is whether the register is an alternative to or complement of the e-recovery system in DIA. I didn't raise this issue because we focused on judicial aspects of the national system, the administrative mechanisms for the compensation. And here we use compensation when it comes to damaged or destroyed real estate. It is the will and the position of the Ukrainian government. In no way does it prevent your filing a claim to the register. That's one thing. Another thing is that if you file a claim to the register, you can also turn to the e-recovery in DIA. About 405 users that have filed their claims to the register have also used the opportunities in e-recovery in DIA. And then we should look at how much compensation was awarded and then how much of that has already been paid. And then it's up to the Commission to decide whether this part should be subtracted from the overall amount. And you know that we are all speaking about the liability of the aggressor state. And e-recovery is a positive will of the Ukrainian state to support Ukrainian citizens. And the nature of those compensation payments is different. The compensations paid at the national level has nothing to do with the international compensation mechanism. And the fifth argument here, it's not only about the recovery program, it pertains to also IDPs, to missing persons, to all illegal deprivation of liberty, etc. So the overall approach is as follows. If a person is part of the national register, then this information will be known to the register. But if an individual is not part of the national registers, it won't be the obstacle for this individual to resort to the register of damage. Okay, since we haven't got any further questions, those who are not very hungry can come up to the panelists either right now or during the lunch break. Let us thank all of the panelists, those online and offline. Thank you very much for your generous sharing of your ideas. We will be back within 40 minutes. Now, lunch will be served on the 8th floor. Please be back
Вітання, шановні учасники. Раді бачити вас знову і раді перейти до нашої наступної секції. Маємо честь і приємність оголосити початок секції номер 6 «Гендерне правосуддя під час війни».
Gender-sensitive justice in time of war. On the way of people-centric approach. І note speech Тетяна Фурель, Head of Department of National School of Judges.
Доброго дня, шановні учасники і учасниці.
Good afternoon, dear participants. One of the topics that I wanted to discuss at Lviv Forum for quite a long time, despite the fact that Lviv Forum moved to Kiev, to look at case law of European Court of Human Rights through gender prism. Many terms were used in English, how to translate them, fact sheets on gender significance is 30 pages long. If we include domestic violence issues and similar issues. I can hardly describe the stories of applicants or about legal position of European Court of Human Rights. I would look at gender problem from other point of view. Since this session is almost final, I would like to reflect what relevance was used quite often, both in introductory speech of President of Supreme Court of Kravchenko, then Mykola Gratovsky spoke. Later, other participants used relevance of substantiation, relevance of use of case law European Court. If you remember, 2019, at the 8th Forum, judge from Azerbaijan, Latif Husseinov, talking about judicial reasoning, used the case at national level. That was the case of compensation of damage caused to health because of an unsuccessful operation. As a result of that, a woman, a farm from other reasons, painful syndrome, impossibility to stand and stand without pain, she lost possibility to wage sexual life. When Portuguese Supreme Court reviewed this case, it reduced amount of compensation considerably. It ruled that depriving her of ability to conduct sexual life at age of 50 will not cause serious damage. And the argument that she doesn't need the domestic helper, her children are adults, she has only husband who she should care of. This decision of the court was used in the course of Kiev School, National School of Judges, in the course gender violence, and I'm very pleased to see those who took part in the liberation of this court in this room. And I hope very much that at this forum, there will be not only my presentation, but there will be a panel on subject discussion, and we shall discuss it with the gender balanced participation of panelists. Gender stereotypes have direct impact at perception by the judge of the gender of party to the hearing. Gender stereotype can cause to impartial and discriminational approach of one of the parties in court decision that is not in line with requirement of being well-founded. A judge of European Court of Human Rights talking about reasoning court judgment used gender-sensitive case. He could have used other case, but he chose this case to emphasize importance of this problem. I would like to use the mirrored case and to show that there are court judgments where at first sight it's difficult to differentiate a gender component. Still, you can see consistent attitude of judges. Principle of efficiency and not illusionary nature applied. Convention intends to safeguard not theoretical rights by practical rights. You all know that, you read it. It is reflected in thousands of judgments. Ailey against Ireland. This is an old case, classical example, as violation of right of access to court. But there is other context in which conditions court was deciding whether there was violation of access to trial or not. Back in 1983, the procedure was different. There is judgment of 1979, 20 years before Istanbul Convention was adopted. Judgment of European Court, the word gender stereotype, domestic violence was not used at all. However, next time, when you hear about this case, I would like you to remember other quotation. Court ruled that disputes, the claimant was a woman whose husband was convicted for beating her. She could not divorce him because in Ireland it was not possible to make a divorce, but she asked court to separate them. But she could not find free legal assistance. In our case, we would call it disputes in family relations. Other quotation. Court thinks hardly plausible that other person in place of Mrs. Kelly could effectively represent its position. That was the answer to questions raised by court. In all 255 court proceedings about separate living started in Ireland from 1972 to 89, applicants were presented by lawyers. Hence, we may conclude that possibility to speak to the court does not give the applicant right for effective access to court.
Is it gender sensitive? Did the European Court apply gender sensitive approach while considering it? I think that the answer is evident. Likewise, in the case of Carvalho-Kind and the Airy case is all about the justification of court decisions, and it is important that person or people-centered approach should include the necessary research. But we have certain issues with statistics, the court statistics. It saddens me to admit that the number of convicted individuals as well as detained individuals is accurate, but in other jurisdictions, say administrative or civil, the statistics only uses cases and materials. That's the number of filed claims considered within the time frames, those which were turned down, etc. But this statistics does not, or these statistic data do not seem to take into account the individuals, nor do we have the studies that would address legal or justice needs. There's other research conducted with a different purpose. One of them is the research on what Ukrainians know and think about human rights. The first iteration of this study was carried out in 2014. The last one was in 2023 after the large-scale invasion, and it showed not only the change in the public sentiment, but also certain gender variances. There are differences amongst various groups of population when it comes to the weight of certain rights. Men, more often than women, believe that the right to freedom and personal immunity is more valid. In women, instead, paid more attention to the right to work and just remuneration for work, which is quite understandable. After the war, new economic opportunities, after the war began, new economic opportunities arose for women. And now we can see that women are invited to fill in positions that used to be banned for women. And women fought for the cancellation of those bans. Women also pay special attention to the marital rights, and when it came to the violation of rights, women more often than not refer to the violation of their right to social protection. The importance of the right to social welfare or protection is correlated with the level of incomes for the household. So for women with lower income level, it is more important. For 65% of respondents, the level of income was under the median one, and only for 45% of people with incomes higher than the average. So the gap being 20%. So whereas for women, the right to social protection is more important. So what can we conclude from that? It means that the incomes of women are lower than those of men. Men, in turn, most often spoke about the violation of their right to freedom and personal inviolability. And they also spoke about the freedom of movement and choice of the place of residence. There are differences between male and female responders when it came to respondents, when it came to the police brutality. When it came to effective remedies, we didn't see very substantial differences, but there are some. Men, a bit more than women, believe that prosecutorial service is more effective. Women turned out to be more passive and less successful in fighting for their rights. More than a half of female respondents never tried to fight for their rights. And only 15% of those who did were successful. In the previous survey, not of 2023, the success level of protection of their rights by police officers was 40% and by judges 85%. So the data of this survey demonstrated yet again that the fighting for the rights depends on awareness and income. The respondents with higher level of income and education more often and more successfully protected their rights. I can see a lot of judges in this audience. So my question is to you. Do you observe such trends in the portfolio of your cases? On the other hand, if we look at the responses and understand that most of the most important rights for women are the right to social protection, then does that reflect in your case portfolio? Only 22% of female respondents knew where to get assistance, including pro bono legal aid. And the percentage amongst men is higher, albeit not too much higher. If we look at the reports of the pro bono free legal aid offices, you will see that women come to them oftener than men. And if we look at the entire system of free legal aid, we see that more than 650,000 applications were registered, of which 61% came from women. At the same time, 73% of individuals who seek legal aid on family matters, that is, every third out of four applicants are women. Then when it comes to tax, inheritance, residence, and social protection law, and regarding to the search for missing persons, notification of war crime, getting humanitarian aid, etc. And when it comes to the application from men, most of them pertain to administrative offenses and criminal cases. Just the free legal aid in 2023 gets 55,000 applications, but those are secondary applications. And again, the division between men and women applicants, it would be approximately the same, but women required assistance in representing their rights, and men wanted to know more about remedies in administrative and criminal cases. I would not be quoting all of these statistics. I'm just mentioning them to show it to you that the issues might differ as well as the needs of men and women may and do differ. And one of the new challenges that we are facing today is that rights do not exist on their own, because there are also obligations to protect and defend the country. The Constitution does not specifically underscore that it is exclusively male obligation. We would not now be speaking about the history of our traditions. Why is it presumed that men should be defending the country? And there is a number of publications with the discussion of this issue. But we know that mobilization affects the men of a certain draft age, and deferment in the fulfillment of this obligation, not the right for deferment, as we can sometimes hear, gave rise to several layers of social relations and disputes. And we were stunned with the scale of the growth in aspirations to get a second university diploma or a postgraduate degree, when it was seen as a way to get this deferment for the mobilization. Before the large-scale invasion, the parental leave was claimed by men who were freelancers or representatives of creative occupations. And this is part of the novel Father Taking Parental Leave by Anton Czech. And he was discussing the situation 10 years ago. And you could conclude from that piece of literature that fathers very rarely enjoyed this right to the parental leave. Sometime later, the civil servants started using this way of deferment or making deferment from the military service. However, the caretaker's function was not characteristic of the male behavior before. The unpaid work has always been seen as the prerogative for women rather than men. But once the mobilization started, we can see that men have suddenly shown their will to take care of wives with a disability, elderly parents, and children. During the qualification assessment, one of the judges, when she was asked about a failure to enter one of her family members into her asset declaration, responded something that I still remember. She said, my uncle's wife is not my aunt. And I recollected then when I was analyzing a case of a military serviceman who was trying to be dismissed from service because he had to take care of his stepfather. It's unusual for a middle-aged man to take care of a man who his mother had recently married. That pertains to some other professions or occupations that before the war were not seen as characteristic of the male gender behavior. In the context of the all-out war, Ukraine ratified several international conventions, including the Istanbul Convention. Quite recently, the Rome Statute was ratified, and Ukraine now has applied to several institutions, the EU, and that has been extensively discussed during this forum, but also Ukraine applied to the OECD, the so-called Prosperous Countries Club. And in October 2022, the OECD board recognized Ukraine as a candidate country. A number of recommendational requirements of OECD and requirements on the EU membership are very close.
В 23-му році Рада Організації економічного співробітництва і розвитку схвалила рекомендації з доступу до правосуддя та людиноцентричних систем правосуддя. А ще раніше,
Requirements regarding gender aspect of justice. Earlier, it presented new framework document regarding people-centric justice. That became kind of mantra in our judiciary. 4 components of people-centric approach are development and provision, people-oriented, services of justice, development, reliable mechanisms of justice, using methods to find bottlenecks in justice with orientation at people, possibility of people to defend their own rights, planning, monitoring, and assessment based on factual data, increasing the role of factual data that requires not only availability, quality, and completeness of data, and create people-oriented culture in system of justice. Analysis of this document allows to conclude how OECD countries use motto best policies for better life. One should understand how people-centric approach is used in the West and how it is perceived here. During opening, Marta spoke about unity of science and practice. If we compare it with people-centric approach, must speak about level of Ukrainian academia and practice of OECD. Institute of State Law, named after Koretsky, held a conference devoted to people-centric approach. If I briefly reduce all the approaches used, we call it approach. If Article 3 in the Constitution proclaims that a human being is the highest human value, by definition, people-centrism is the basic principle around which everything else is developing. In this room, not in this, but I mean at previous fora, we spoke about quotation of judgments of European Court, provisions of Constitution, quotation without application. If we look how people-centrism is described in the documents of OECD, this is the approach that put people in the center when developing provision and realization, as well as assessment of state policy, services, procedures in system of justice and outside it. The document contains terms difficult to translate. For instance, justice pathway, the ways that a person chooses when facing particular problem. Legal needs in justice. People-centered justice data.
Вони стосуються даних, які збираються відповідно до стандартів захисту даних, але орієнтовані на людей.
Collected to protect people's rights, but oriented at people and their needs.
Кажу, пройшли цю стадію застосування.
We have passed through this stage of
цитування без застосування.
quotation
Можна
without
скільки завгодно
application.
цитувати статтю 3.
You can
І
quote
вона може
Article
бути майже
3
в кожному
as
судовому
many
рішенні.
times as possible. It could be
Але
mentioned
судова
in every
система,
court
і правова
justice.
система загалом не стане більш людиноцентричною.
But with
Тому
that, judicial system will
зміна
not
підходів
come people-centered
означатиме
more.
орієнтацію на
Approach
збір даних,
will define orientation of collection data,
чоловіків і жінок,
assessment of needs of the people, men and women,
і
understanding their categories, and building effective practices of meeting different needs. And then people-centered approach from declaration will become effective articles. Thank you for your attention.
Дуже дякуємо, пані Тетяно, за таку змістовну, цікаву
Thank
і
you,
детальну
Tatiana, for very interesting and detailed presentation. A lot of things to think about, a lot of work ahead of us. You mentioned challenges that we face, and we must try to find the answers to these challenges. I have the order to invite for keynote speech esteemed guest Mykola Gnatovsky, Justice of European Court of Human Rights from Ukraine. Our new section, Judicial Gross Negligence and its Interpretation by European Court of Human Rights.
Дякую сердечно за надане слово. Вітаю ще раз, шановні колеги. Я дійсно тішуся з того, що є можливість поспілкуватися в такому достатньо
Thank you for this opportunity to communicate and to have a discussion. It is very useful.
Незабаром до режиму відкритого мікрофону, так, то коли можна буде, власне,
program will not be changed, soon we shall have open microphone regime and questions and answers will be provided. Now I will probably start from the topic in the agenda.
Суд робить у випадку, коли йдеться про помилки, недбалості, чи ще як завгодно це може бути національної судової влади.
National judicial authorities make errors, there is negligence. When organizers of the forum formulated this request to speak on this subject, I started thinking there is a direct connection, direct line between my first speech that I made yesterday on subsidiarity and procedural review of the decisions by European Court of Human Rights, and this topic, which is connected with mistakes. I shall start not from case law of European Court, and now you will understand why. In fact, who should correct judicial mistakes? Let us raise the question. This is the function of the higher instance court. The system of courts is functioning in such a way there is a possibility, in most cases, there is a possibility to complain to the appeal instance. After first instance court, there is a possibility of revision of this judgment, make appeal on facts and on law, and appeal court had broader possibilities to correct these mistakes of first instance courts, but higher responsibility, and there is a possibility to appeal exceptionally on matters on law, in our tradition of civil law, in German system of law, which is called Casation. The best way to translate English word cassation does appeal on the points of law. It's much better. It is more understandable for lawyers of English and American legal tradition. You know that for criminal cases, this is the issue of human rights, rights for appeal, because this is the case of interference of the state into the life of a person, very profound interference that is most significant for people, but in civil cases, de facto, it exists as well. How state regulates access to these instances? This is also a question of choice, discretion of the state. Famous cassation filters, these are open questions. In Europe, practice is different. If there are cassation courts in Europe that are not loaded, very few cases come to them, because filters are extremely high and they do not allow most of cases to this level. But Ukraine is the country with record number of cases at appeal level. This level is much, much higher than average indicator in Europe. Sometimes judges of cassation courts and courts themselves even do not want to have more detailed filters, giving more possibility for revision. So there are three instances in the structure, and this is the task of domestic courts to correct mistakes made. In principle, such a system must function. But on the other hand, I think it's no secret that mistakes could be made at any level. And there are situations in different countries, even in the European Court. It's different to differentiate why higher instance court came to quite surprising conclusion. Today, just come back from consideration of such type of case. There should be a point to end it. Otherwise, there will be eternal, long-lasting appealing system. There is Supreme Court. I'm glad that its representative is still here. In principle, it's quite possible to turn the system into complete absurdity if we open filters, revision because of special circumstances that undermines rule of law, not less than individual court mistakes. Not abiding by princip res judicata, in my view, is a more threat if it's used systemically. It's a greater threat to public order compared with individual mistakes of judges in individual cases. You may not agree with it. Any generic statement cannot be correct in all cases, but anyway, considerations of res judicata, of legal certainty, should not disappear from the picture. If they disappear, then for sure we must wait for a problem. What next? In order to function and fulfill its function, to establish rule of law, the courts must understand that without powerful judicial system, there will be no rule of law.
So the extent to which there is the external interference with the judicial system is a matter that should be extremely cautiously considered. There is a desire, of course, to fight with a judge whose decisions we don't like. So can we complain to the authorities that are in charge of disciplining of judges? Should we make sure that disciplinary sanctions are taken against the judge? Should we consider criminal liability, perhaps? Yeah, there would be people who would enjoy doing that, or just dismiss the judge for taking a wrong, quote unquote, decision. And this, since you know the recent case law regarding Ukraine about the Constitutional Court justices, this is of Cherenko and Kolos versus Ukraine and Golovin versus Ukraine. They are similar cases. They pertain to the same situation, that is making the judge liable, that's dismissing the judge for, again, quote unquote, wrong decisions. And we don't know who was it to decide that the decision was wrong. Some would say it was Parliament, some would say it's the society, but still it is punishment for the, again, quote unquote, wrong decision. And the consideration of those cases by the European Court of Human Rights was so done that it took the European judges some time to comprehend the situation in which a judge could be punished for rendering a wrong decision. In the case of Kolos and Golovin, you will know that the notion of the violation of the judicial oath was not quite clear as a notion. And then the question is, was it wrong? Was it a mistake to vote for such a decision that actually reinstated the constitution that vested more powers in the president? Was it a mistake? Was it lack of responsibility and accountability, or was it their legitimate personal opinion? And from the very beginning, this option was excluded. So it is a very tough issue that should be contextualized and assessed in the context of our recent history. And we cannot turn a blind eye to that history. That's why the decisions are as they are, or judgments of the ECHR. But then what should be done to correct the judicial mistake or judicial gross negligence? The cases where concepts of this sort are being used or applied are very
Причина тут полягає саме в тому, що ми обговорювали
rare.
вчора. Це і
And the reason is what we discussed yesterday. It's about the principle of subsidiarity and the doctrine of the fourth instance. The European Court of Human Rights is not the fourth instance court called to correct the mistakes of any of the three instances of the national courts or domestic courts. It's not the function of the European Court. So, as matters stand, and I recollected one interesting case, I will comment on it a bit later. So, in most cases, we don't see such cases in the database of the European Court because attempts to complain about the national judges' mistakes will end in the recognition of admissibility of the application, and the decision will never be publicized, and it will just be in communication between the applicant and the registry. So for the sole judges' decisions back in 1999, the Grand Chamber in the case de Series versus Spain, paragraph 28 said, in the extent to which the application can be seen as a necessity to re-evaluate the assessment of evidence and the outcome of the consideration by the national court, the court, that is the ECHR, emphasizes that according to Article 19 of the Convention, its duty is to ensure the honoring of obligations undertaken by the high parties to the Convention. And the European Court of Human Rights should not consider the mistakes of fact or law or errors of fact or law, which according to the claims of the applicant were committed by the national court, unless they violate the rights and freedoms guaranteed by the Convention. Moreover, whereas Article 6 guarantees the right to fair trial, it does not establish any rules about the admissibility of evidence and ways to assess them. This should be regulated by the national law and decided by the national courts. And this is the general approach. But when the European Court of Human Rights does pay attention to the mistakes, you can understand that from the quotation, when they see the obvious, the egregious mistakes, which mean the clear arbitrariness by representatives of the judiciary. So when yesterday I spoke about relevant and sufficient reasoning and arguments, but all the parties, so they need to motivate, to reason the decision when that's not the case, when there's none of those elements. In such very rare cases, the European Court of Human Rights would do it. Now, vis-a-vis Ukraine, there are several cases of this sort. I will later comment on them, but should mention another notion in this respect, and that is errors tantamount to clear denial of justice. And that's another key term that you should be looking for when you study case law of the ECHR. So flagrant denial of justice would be, or just denial of justice, sometimes without flagrant, can be met in the case law and jurisprudence of the court. So it should be evident that there was miscarriage of justice or that justice never took place. But those situations are unique. And the example, the only case about Ukraine with the manifest error was established by the court, and that's the case that we mentioned yesterday, Buchan number 2. No other Ukrainian cases with such stringent language could be found, even though there are certain cases where the court found violation of Article 6, but uses fairly mild terminology, speaking about a lack of reasoning or insufficient reasoning. But when I read those judgments taken without my participation, so I'm in a situation that is the same as yours. So I read it like this. The judges believe that there was a manifest error, but they would not use such very strict terminology, and they would say that there is no sufficient reasoning. They had certain questions, but those questions were not answered by the decisions of the national courts. And you can't understand why those arguments were not made by the court. It's Bendersky versus Ukraine, for example, 2007. Then the judgment in Mala versus Ukraine, 2014. Then in 2019, there was a committee decision in Kostenko and others versus Ukraine. But now, frankly speaking, we've got the practice in the court whereby there is a category of cases related to the lack of reasoning. And when they see that these are relatively simple cases, then they would be decisions of the so-called tabular format. In the internal jargon, we call them fast-track cases. That's a well-established practice, and we can refer to the fast-track committee decision, Leontiev and others versus Ukraine of 2023. A table would be added, and you can see exact events that happened to the applicants and why the violation was established. Then in criminal cases, a lack of motivation or reasoning will be associated with the violation of Article 6, and it is the classical case mentioned several times, even here. Yonkova versus Ukraine and Zhank versus Ukraine, again, looked at from the optics of lack of motivation. When it comes to the manifest judicial error, then we speak about the case, which is very illustrative in this respect. It is called Angelkovic versus Serbia. Angelkovic versus Serbia, a recent case of 2013, and it is about the arbitrary judgment of the National Court or decision of the National Court. There was a civil claim against an employer. It was satisfied in the trial instance, and it was a totally trivial case, but later the decision was reversed by the Court of Appeal with no grounds provided. It doesn't happen too often, but in this case, Angelica versus Serbia, point 20 or paragraph 27. If you look for this judgment, look for Andelikovic with the special apocryphic sign. And the court says that in this very case, it didn't happen.
Balaktash Bingulu against Turkey. The court says that it was not there. A judgment from 2021, paragraph from 80 to 82. But these are exceptions. The issues regarding which European Court has always been and remains very careful. This denial of justice, this concept that broader than judicial error, in the brutal way, you can find it in quasi-state case, Dashko and others against Moldova and Russia. This is one of the aspects of Yulashko case. Near the concept that's difficult to translate into Ukrainian is a bordering concept. Miscarriage of justice.
Miscarriage of justice, як би ви перекладали? А? Помилка? Не належить. Помилка, ви розумієте? Miscarriage – це дуже серйозно, ви знаєте, медичне значення слова miscarriage, так?
You know medical meaning of the word miscarriage. It's the same in the law. It is in Article 14 in International Covenant of Civil and Political Rights. Protocols to European Convention. If entire system of justice didn't work properly regarding that person, it was miscarriage of justice, then that person is entitled for compensation. And the standard of evidence is very high. It's not just one small judicial mistake, but it's very serious, gross mistake that caused conviction of a person for crime that the person never committed. And the standard of proof is very, very high. There were repeated attempts to resolve this issue in the British context through the second aspect of presumption of innocence situation when the state is treating that person as if that person is guilty of the crime rather than using presumption of innocence. Finally, the case was terminated, but still they continue treating that person as if that person is guilty. That issue was raised in the context when person was convicted for serious crime, that a person is serving a sentence, then new evidence appears, new possibility to assess it, but it turns out that outside reasonable doubt, you cannot prove that that person committed a crime. That person is in suspended position. On the one hand, persecution is terminated, but the person spent in prison 70 years for the crime that person probably not committed, but probably committed, we do not know for sure. Beyond reasonable doubt, that person cannot be considered guilty. A person asks compensation, but the answer is you have not proved that you have not committed this crime. And that person tries it. But the requirement of the British legislation in England, Wales, North Ireland, there is a norm according to which compensation is paid when, on the contrary, beyond reasonable doubt, it is clear that a person has not committed a crime. And the victims of this very English system, which is not people-friendly, they apply to European Court trying to get compensation, not through the other articles, but because second part of presumption of innocence provision was violated. The situation is getting more complicated because Britain has not ratified Protocol number 7. They tried to get it through Protocol 6, Part 2. In Neelan and Halligan case against UK, closed this possibility. Grand Chamber said that we sympathize very much with you, but we don't see friendly presumption of innocence. We don't see it. It's difficult. 12-5, but the conclusion was no. I was among those judges dealing with this case for quite a long time. It was not a very easy case. Summing up, I will conclude. Doctrine of the fourth instance is alive. This morning, we discussed it with Stanislav Ivanovich from Supreme Court. European Court of Human Rights consistently insists that it is not the fourth instance court and will continue doing it. It may start arguing with national court only when, as a result, rights and liberties guaranteed by convention are violated, not when a person is not satisfied with this result of consideration of national court. 50% of people that go to court are not satisfied with the result. In this sense, subsidiarity lives and overcoming. And post-court review will be used even future. With that, I want to finish. I thank you for attention. Look forward to your questions.
Вельми шановному Миколі Миколаєвичу за таку цікаву доповідь.
I want to thank esteemed Mykola Mykolaievich for his presentation. Then I give the floor to our moderator, who is Deputy Head of Secretariat of Supreme Court. Good afternoon, esteemed colleagues. We are all in marathon, but Mykola Gnatovsky is real marathon running because he has covered so many issues during 2 days of the forum. We're very thankful to you for that, but we shall kindly ask for some more time for your attention because some time is left for three microphones. First, a few words from me. With great interest, I read last judgment regarding a British man who was convicted wrongly for 17 years. I read this judgment several times to understand it correctly. This right for compensation followed from the presumption that the state has monopoly for violence. And I think for the explanation that you provided, this judgment of the court became more clear for me. In the first panel, we spoke about relation between the right of European Court of Human Rights and the law of European Court of Justice. I recollected famous academic Mr. Verlansky, who created a theory that combines all branches of science. Bogdan Kisikivsky, Adelaide, proved the theory of universality of law. He was saying division of law into spheres prevents our search for justice. He said that we must look for universality. It's difficult to find the separation line between civilian law in Ukraine and other countries. At theoretical level, probably fair will be. In Poland, one approach is used, and Ukraine conceptually different. Consideration of national peculiarities is important. For younger colleagues, I would advise you to look at this universalization of law and this question of European consensus that European Court of Human Rights and Court of Justice achieved in close discussion shows that great attention is paid to the search to such consensus. Who has questions probably pertaining to today's presentation, but not only general case law of European Court of Human Rights or standards of Council of Europe. Open microphone for any questions. Here comes the question. Introduce yourself. Tamara Dudas, Lviv National University. My question pertains to criteria for compensation of damage of European Court of Human Rights. In several declarations of high-level conferences, was mentioned that this criteria will be publicized, but as far as I know, it was not done. Can we hope that it will be done? If not, then why? Thank you. Thank you for your question.
Працює. Да, працює.
Now microphone is working.
Зараз ми на нашого технічного співробітника попросимо. Вімкнули ви його, так? Можливо, тут.
Пане Васиме, тоді позичу просто. Дякую дуже. Дякую ще раз, пані Тамаро.
Thank you, Tamara, for your question. Wonderful question, but not easy. As far as I know,
планів оприлюднювати окремий документ, чи там наші внутрішні розрахунки.
Plans to publicize a certain document, what are our internal calculations when deciding on non-material, non-pecuniary damage based on Article 41. I didn't know about such plans, that somebody planned to publicize it. Why? Because court is not the body that creates norms. The court cannot establish rules. I understand. Sometimes there is impression that for national courts it would be good to know what European court is using.
Дуже специфічну природу оцієї just satisfaction, та справедливої сатисфакції, яка виплачується за 41 статтею. Якщо ми уважно подивимося текст 41 статті, там написано,
very carefully at the text of Article 41, it says to the extent that it is not addressed at the national level.
пропонує достатньо специфічне тлумачення цієї.
And the case law interpreted this provision in a specific way because there is a desire to award this kind of damage and to see whether at the national level everything is lost. And the nature of this damage is such that we find also violation of the convention on the part of the state, and it will be the mechanism of international accountability. There should be restitution, first of all, and the compensation, which in the antique legal language is called just satisfaction, which is not the vocabulary of the international law of today. Nonetheless, that's how it is formulated in the convention, and it is seen as a complementary to what the violator state should pay. And if we look at the case law of the court in dynamics, and I will pretend I don't know the internal domestic court decisions that are just benchmarks. It's not just the schedule of awards. Then empirically, one can see that various violations of various articles are appraised in various ways, and these articles also can yield different results depending on how they are in conjunction with one another. What are the vulnerabilities of the applicant, etc. And if we just look at the amounts awarded to different countries for this same or seemingly similar violations, then the court takes into account the economic standing of the relevant country, because violations that Ukraine unfortunately commits in a Western country would cost, quote unquote, much more. So a lot of different factors contribute to the awarded amount, and the general mood or sentiment in the court is that the publication of any such documents will raise more questions than the absence of such a publication. And the court cannot start looking for excuses and start explaining why they ruled this or that way. So the only form of communication of the court with the world is through its judgments. And I won't open any secrets if I say that the ECHR seeks improvement of its own case law when it comes to Article 41, and there is an ongoing search for the language that would reflect subsidiarity appropriately. That is the opportunity to address the case at the national level, and the case that we considered before it is a very bright illustration how the role of national courts should be taken into account. Thank you very much for this very exhaustive answer to the questions. Any other questions or comments? While our participants are thinking on their questions, I will ask one if I may, and it is more about the ethics of the legal professionals. In Vilnius, quite recently at a conference, the freedom of expression was discussed in conjunction with the communication technologies which are emerging. Of course, the heritage, say, media could be made accountable for many cases, but or many violations. But if we look at certain situations where social media are used to exert pressure by representatives of the civil society or legal professionals on the judges indirectly, particularly when they say that if the case is resolved in this way rather than in that way, it will testify that a judge is not a person of integrity. So isn't that too extreme an approach when we seek a balance with the right to a fair trial? So this pressure can, in theory, nudge a person to take a certain decision with all of the considerations of judicial independence, etc. Yeah, a very interesting and fairly difficult question, I should say. This balance between freedom of expression and improper pressure. So the convention is being interpreted so that it should protect and defend courts and judges. Because no rule of law is possible without an independent court. During the lunch, lunchtime, I met with my former students, and they asked me about my attitude to the current judicial reform. And the point I made was that the independent court is essential for the effective mechanisms of self-cleansing so that we can ensure the rule of law. And the protection of courts and judges should be guaranteed. But in what situation which measures would be proportional and reasonable is difficult to say. From the standing of the ethics of defense counsels or procedural safeguards, they have very tangible interest in a certain case. They've got an opportunity to express their opinion where it grows into the pressure brought to bear on the judges is a very fine line. So there is no ubiquitous and unambiguous answer to it. Other questions? Good afternoon, dear speakers. I'm Victoria Kroto. I'm a student of the Law School of Kiev, Taras Shevchenko University. You spoke about, Mr. Grankovsky, about the use of certain filters for the cassation instances in Europe, and that our national system is less inclined to use such filters. Don't we have to introduce the use of such filters more extensively to the Constitutional Court so that the caseload on of the cassation courts could be reduced? Thank you for this question. I also was thinking about asking you about it when we were negotiating with the European Commission as part of the screening. They were asking us whether we are going to do something with the reduction of the caseload, and our answer was yes, but when Fukuyama was writing his wonderful work, said that democracy should emerge in a state at a certain period of its history and development, and sometimes when introduced prematurely, it might be detrimental to this state. So now that we are speaking about the uniformity of court practices, it cannot be achieved within a very brief period of time. So perhaps we can think of expanding the filters, and then the situation will improve organically. Thank you, Victoria, for your question. And Nassim, for the continuation thereof, there is a formalistic, formal answer in that it's a discretion of the state, and the state knows better what filters should be established at the cassation instance. And that is a matter of the legal policy of the state. And it should be clearly communicated, and it should take on board certain requirements to the length of the proceedings, because if the cassation instance is overwhelmed, overloaded, then there would be a threat that Article 6 would be violated in this context. But if I give you a frank answer, that would be as follows. I don't know how to answer it. Setting up the Supreme Court that would be somewhere in the clouds, getting one case out of 10,000 would not be difficult, perhaps, but would that respond to the societal demand for justice? I'm not sure. So, you can say that, yeah, just install as many filters as possible, make them very stringent, and your caseload would go down, would plummet. But I think that the Supreme Court is capable of regulating these matters on itself. And as far as I understand the position of the Supreme Court, it is well positioned to publish policies to adjust such filters. The Constitutional Court actually spoke about filters ratio and valoris, and they are widespread in Europe, European courts. And this is the position of the Constitutional Court. So there are, again, a lot of factors at play. And now I would give the floor to Justice Stanislav Kravchenko, Chief Justice of the Supreme Court. There might be questions to ask of you as well. Now, and the legislator, when it comes to minor cases, has responded to the position of the Constitutional Court, and a dialogue was conducted with the Supreme Court to look for a balanced approach, since it is a significant matter for the judicial system, the lack of candidates for the judicial positions. Yeah. Any other questions? Yes, I see a raised hand. Good afternoon. I'm Simichuk Mykola, students of the Lviv National Ivan Franko University. My question is to Mr. Gnatovsky, to Judge Gnatovsky. Yesterday, Rasim raised the issue of the rule of law, and I had an honor and an opportunity to participate in the summer school on criminal justice, where these issues were discussed, and we had a question whether the rule of law is applied as a practice or whether it is more of a theoretic notion. So what do you think about the rule of law and its manifestation in the jurisdiction of the European Court of Human Rights? Yeah, that's a huge question, you know, and I will be very brief in answering it. When it comes to my personal attitude from the very first decisions of this court vis-à-vis Ukraine, I was desperate.
I had the impression that we're getting away from practical application of this concept to theorizing. As regards case law of European Court of Human Rights, rule of law for us, first of all, is independent and impartial court. Problems should be resolved by such kind of court. Rule of law means legal certainty in its different aspects. Well, this is in place. In practical aspect, you can say that we are at least on the way to achieving the rule of law. If one or two elements are lacking or are under attack, it is clear that the country will feel problems with the rule of law. I try to look at it in the most practical manner. Thank you. Colleagues, participants, more questions?
Назвати Владислав Протошок. Я також є студентом.
I'm Vladislav Protoshok, also student of Franko Lviv University, Department of Law. I have a question to Mykola Gnatovsky.
На вашу думку, наскільки великий
In
внесок
your
може внести
opinion,
ЄСПЛ, практика ЄСПЛ, у боротьбі з глобальним потеплінням,
how
користуючись тим
can
інструментарієм, що у нього
European
є
Court of Human Rights use its instruments
для вирішення
to make contribution to resolve environmental problems, global warming in particular? In April, European Court made a judgment against Switzerland where the subject was global warming and quality of life of people. It is quite important for Ukrainian society in particular. There are many applications, certain number of applications to European Court regarding worsening of life of Ukrainian people by hostilities made by Russia and environmental crime as part of life. I think we must separate issues, Russian aggression and global warming. As regards global warming, instruments that European Court has, they are quite considerable. If you could be in Strasbourg on the day when Grand Shape was making judgment, temperature in the city dropped some -5 degrees on that day. But talking seriously, Strasbourg Court has no instruments to fight global warming. There is a judgment which is quite interesting, the case against Switzerland that you mentioned. The court ruled our conversation about process-based review. When national courts review the issue of global warming, on some environmental issues, on discharges, emissions, they must when making decisions. Take into account this argumentation and be in line with that. That's what European court said, but even that looked quite revolutionary. The government said that they will not fulfill it, and they said they have already fulfilled it. The popularity of my esteemed colleague, Judge Ike, who was the only one who wrote his separate opinion. All others who didn't like it quoted his separate opinion. It is clear that this is quite opportunities of Strasbourg Court are very modest. This is locus standi of applicants. And this is the reason why the case that was publicized maximum and a case against 62 European countries who were members of Paris Agreement, this case was not admitted by Grand Chamber because they didn't have enough proof. And the third case against France didn't move on. For the same reason, many people expected that Swiss pensioners who are members of this climatic civil society organization do not have this status. But European Court said the association that has statute, they have the statute, at least partially, but our possibilities are quite limited. But I'm afraid these are not the questions to be resolved easily through prism of human rights. You need other instruments. Thank you. I want to add from myself. This year in Strasbourg there was another forum with representatives of Supreme Courts on climate change and the role of courts in that. There are judgments of Supreme Courts of Netherlands, Germany, France, and probably UK. You can find them. General concept of this forum was bringing us to the conclusion that from all subject authorities, courts are probably most stable. Politicians come to power, say, in 2015. They say, we shall reduce emissions by 40%. Then they leave. Other politicians come, and they don't want to spend money. Previous politicians won election because of the promise, but others do not want to lose their voters when spending them. Even due to the fact that 2040, where this reduction should take place, states were supposed to start reporting now. And what interests were protected? The interest of future generation. That was interesting interpretation. It comes from German contribution. Please look at the proceedings of this forum of 2024. There are many up-to-date materials on that. Good evening, colleagues. Repeto, a lawyer and postgraduate students of Shevchenko University. Practical question. Very often, I face clients regarding blocking of tax invoices. I explain. As a rule, they lose at appeal court to tax authorities. But according to the rules, they are relieved from paying some military contribution. But tax authorities is ignoring principle of legal certainty. What I'm interested, do judges raise this issue between themselves Take into account difficult situation with administrative court in the city of Kiev.
Цікаве питання,
An
насправді,
interesting question.
дуже серйозну тему.
In fact, you raise a serious topic, but I would rather address it not to the courts, but to the approach of the state in general. It pertains not only to tax invoices. This is one of the most painful issues. I mentioned many judgments regarding violation of commitment by Ukraine, not declared detention, unmotivated extension of pretrial detention. These are the problems that we're discussing for many years. And looks like there is a case law, clear legal stance expressed. Why it's being done? You will surprise. For if the tax inspector doesn't do it,
подальших і подальших. А чому? Чому не використані всі засоби? І що стосується слідчого, ми могли чути питання буде перевіряти антикорупційне відділ, чого ти не вніс.
He didn't do it. Anti-corruption department will start inquiry. As judges, we are discussing it between ourselves, but we cannot impact it. Level of legal awareness. And talking about tax authorities, last year, Supreme Court reviewed more than 80,000 cases. When you mention figures, people think that something is wrong. More than half are in administrative justice. Typical cases that you mentioned with clear position. Maybe they're not so complicated, but surely the level of legal culture should be raised. And this should be resolved comprehensively. There could not be 5 or 10,000 of similar applications. It's difficult to enforce them. What's the use of doing it?
Дякуємо за запитання, за відповіді. Навіть найдовший марафон, коли закінчується. Якщо є ще одне питання,
even marathon is ending someday. If there is one more question, we should take it and discuss it. If no more questions, I propose to start summarizing the result. From me, myself, I would like to express gratitude to all co-organizers that, first of all, were inspired by this idea to hold forum many years ago. They didn't reject it this year, took a lot of efforts to organize it this year. Our word of thanks to colleagues from Lviv University, from Project of Council of Europe, from OSCE Support Programme for Ukraine, from the staff of Supreme Court that took a lot of efforts to enable this event. Sorry for taking some of your time. I could not avoid saying on that because I witnessed all this organization and decided to express my gratitude. Then for diplomatic part, I invite Mykola and Stanislav Ivanovich to conclude. Thank you, Rasim. I will not take much time. You're probably tired from my voice for this today. But first of all, sincere gratitude to all those who organized this forum. It seems to me it raised to the new level of quality, not traditional devotion to this idea of Lviv University and its law department. Thanks to permanent support of OSCE, which is even more prominent, taking into account organizational problems that OSCE mission in Ukraine had to overcome to be able to continue its activities. So words of gratitude to all colleagues who are engaged in it. Words of gratitude to Council of Europe office, programs that are supporting Supreme Court, Ukrainian courts. This is great work. These components ensure stable success of this forum in Lviv. But raising it to high level is due to Supreme Court. Words of gratitude to Stanislav Ivanovich and Rasim and to all justices Supreme Court. It's a great privilege having justices of Supreme Court. Despite their busy schedule, they follow example of President of the Court and take part in the forum. I'm glad to see students, I'm glad to see practitioners. It's a very well balanced, versatile audience. It was real great pleasure, so I hope next year this experience will be repeated. Dear colleagues, I would like to start my words of gratitude to Lviv University, first of all. I knew it, but it was good that Supreme Court was mentioned. Judges, colleagues who started this work with us are now justices of Supreme Court. Now, I want to address students who are in the room. Please believe me, your insistence will help you to move further and have career development. In Supreme Court, we use this criterion of professionalism. This is the main component. Great words and thanks to School of Judges, to OSCE, Council of Europe office.
I would not, of course, boast that we contributed a lot to the success of this event. I think everyone deserves to be commended. Yesterday, we said that we hoped it would be interesting and enlightening. It has been very interesting, particularly when it comes to our analysis of historic developments from the ancient Greek times till today. So we discussed the principle of subsidiarity and other very important matters. My feeling is that it has been a successful event. And we see that the world is developing very dynamically. And I think that whenever we reiterate some of the notions and trends, we would be moving ahead as well. And I hope that the national courts, including the Supreme Court, will be in a position to say something interesting to the judicial community of Europe. Thank you very much. Thank you very much, colleagues. This ends our two-day marathon. Thank you, esteemed participants. So you are welcome at the 8th level, and see you next